Good afternoon, everybody, and welcome to the Appellate Division First Department. We are now in session on our virtual session for Tuesday, February 15th, 2022. I am going to call the calendar. Please don't answer. Susanna, our chief clerk, has already indicated that all the attorneys that are supposed to be here are here. I'm just going to read the calendar and go over the times for the record. The first case is People versus Christopher Coachman. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Noble Desktop against American Graphics. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. The next two cases, J. Jason and E. Gwendolyn, are family court cases, and they are both marked submitted. Moser versus New York City Transit Authority. The Transit Authority has 5 minutes and 2 for rebuttal. The respondent plaintiff has 5 minutes. Wesco Insurance versus High Rise Steel. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Payne versus NSH Community. The appellant, has 4 minutes and 1 in rebuttal. We gave 5 minutes to the plaintiff, and NSH Turner has 4 minutes and 1 for rebuttal because they're a cross appellant. Moss versus Marymount, Manhattan. The appellant has 5 minutes and 2 for rebuttal. The plaintiff has 5 minutes, and we neglected to give the co-defendant Faliat time, but you do have 4 minutes. I'm sorry for the confusion on the form that came out in advance, but you do have 4 minutes.
Thank you, Your Honor.
Yes, sorry about that. People versus Nunez. The appellant has 5 minutes and 1 for rebuttal. The respondent has 5 minutes. City of Pittsburgh, that case is now going to be marked submitted on consent of all parties, waiting for the settlement to be finalized and approved by Supreme Court. So we will hold that in abeyance. Thank you. Word of God versus Vimeo. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Max versus ALP. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. New York Studios versus Steiner Digital Studios. The appellant has 7 minutes and 2 for rebuttal. The respondent has 7 minutes. And Lesser versus Lesser is marked submitted. Okay, so I just ask for all the attorneys to please remember to keep your microphones muted until your case is called. Otherwise, we hear reverberation. I myself have construction going on upstairs. I can't control it, but hopefully it won't cause too much trouble. Everybody just try to be careful about speaking over each other. We've all been doing this long enough, but we know that there's always a second or two delay. So just try to be careful. If you see the judges are asking something, why don't you just wait until they finish? And if I see that too many people are speaking at the same time, I'll try to act as the traffic cop and keep the time. So we're going to do the best we can. We usually do. And we're now ready for the first case to be argued. That is People versus Coachman. Mr. Wiener for the defendant. Are you here?
Yes, I am here.
Okay, counsel, you may begin.
Thank you, Your Honor. I'm Benjamin Weiner on behalf of appellant Christopher Coachman. 2 jury charging errors require reversal in this case. First, the court improperly instructed the jury that they should go on to consider the lesser included offense of first-degree manslaughter if they acquitted Mr. Coachman of the top count of second-degree murder for any reason other than justification.
Judge Gesmer, you're muted.
Counsel, this is Justice Gesmer. Can you, as far as I could tell, that issue was not preserved. Why should we consider it even though it was not preserved?
You're correct, Your Honor. That issue is not preserved, but it is precisely the same kind of error that this court identified in People versus Velez and its progeny with respect to justification defenses, and which the court repeatedly reversed in the interest of justice. And the two errors are the same because, just like the justification defense at issue in Velez, the intoxication defense here applied equally to the greater count and the lesser count.
Counsel, this is Judge Owen. Justification means there's no criminal responsibility for justification. Intoxication is very different from justification, right? I mean, intoxication is negating an element, whereas justification says there's no criminal intent whatsoever. I mean, there's apples and oranges when you're trying to put justification and intoxication together in the same box, I think. Correct me if I'm wrong.
Well, Your Honor, the two defenses are identical in the crucial respect. Obviously, the substance of the defenses is different, but the crucial...
Very, very different. They're very different.
But the crucial piece of a justification defense that led to an error in Velez was that it applied equally to the greater and lesser counts, that you could not be justified as to the greater count, but not as the lesser count. So too, the intoxication defense here. Respondent does not dispute that if Mr. Coachman was too intoxicated to form the intent to kill, that he also should have been acquitted of the lesser included offense because he was too intoxicated to form the intent to cause serious physical injury. So in that key respect, the two defenses are exactly alike, and the jury charge here led to the possible...
Is first-degree manslaughter the lesser included offense in second-degree murder?
Yes, Your Honor. First-degree manslaughter was a lesser included offense, as was second-degree manslaughter here. The court should have instructed the jury that if they acquitted Mr. Coachman of second-degree murder on intoxication grounds, to go on to the second-degree manslaughter count, not the first-degree manslaughter count. Because
I'm thinking that kind of issues should have been brought up before the trial court. I mean, in Velez, I think, those issues were sort of broached, I think, right? Correct or no?
Not at all, Your Honor. That issue was completely unpreserved in Velez. Just as here, the court followed the CJI instructions, and it wasn't raised at all in Velez or any of its numerous cases following it. And the justification for reaching the issue in the interest of justice is identical in the two cases. I do want to address the error with respect to the justification charge as well. The court should not have charged deadly physical force justification over defense objection where that defense was not supported by a reasonable view of the evidence. Obviously, the jury needed to decide whether Mr. Coachman used ordinary or deadly physical force, and counsel conceded below.
So this is the judge saying, but isn't that the flip side? Wasn't it necessary for the jury to have all that in front of it to be able to make the determination that you were about to say?
Not at all, Your Honor. There was no reason for the jury to be instructed about the circumstances under which Mr. Coachman was justified in using deadly physical force. Certainly, deadly physical force needed to be defined.
Well, it puts it in context, doesn't it? Put it in context because the jury has to decide whether or not whether it's ordinary force, but to have the charge on deadly force, it puts in context for the jury to make a proper determination. No.
Not at all, Your Honor. It adds, it injects an element of confusion. The issue for the jury here was, did Mr. Coachman use ordinary or deadly physical force? If he used ordinary physical force, was he justified? If he used deadly physical force, everyone agreed below that Mr. Coachman was not justified because he had testified that he wasn't threatened with deadly physical force. So that defense of deadly physical force justification was just not in the case at all here. There was no reasonable view of the evidence. And that's why we have this rule that you should only charge defenses that are supported by a reasonable view of the evidence, is to avoid juror confusion and speculation about defenses that aren't in the case. It also put defense counsel in a terrible position here of having to begin his discussion of justification on submission by conceding a point that he could not possibly have won. The very beginning of his defense was, we're not saying he was justified in using deadly physical force. And that, in addition to the confusion that I described before, was damaging to the credibility of the defense in front of the jury. And that's precisely what
was the credibility issue before the jury? I'm sorry, what was the credibility issue?
I'm sorry if I wasn't clear, Your Honor. I'm talking about counsel's credibility with the jury.
Okay,
Counsel
fair
had to begin
Fair enough. I got
by,
it. My mistake.
Thank
I got
you.
it.
And counsel, as to that second issue, was that preserved?
Absolutely, Your Honor. Counsel argued at length that deadly physical force justification should not be charged to the jury for precisely this reason. And the court charged it anyway. So that issue is certainly preserved. And I think in combination with the intoxication issue, both of these errors, when considered together and individually, require reversal of Mr. Coachman's conviction and retrial.
Okay, Mr. Weiner, you will have a couple minutes for rebuttal. If we could hear from the people, Ms. Aldridge.
Good afternoon, ADA Aldridge for the people.
Good afternoon.
Defendant was convicted based on overwhelming evidence. The court
Counsel, regardless, go ahead.
Judge
I was
White?
just gonna, yeah, the question I think we all have is with respect to this justification versus intoxication, assuming it was preserved, because it's not, in the interest of justice, we may review it. Why shouldn't we say that this isn't like a Velez situation here?
Well, as was mentioned previously, justification, intoxication, apples and oranges. And in this instance,
you're listening to my statements. Okay.
The intoxication instruction applied equally to the murder and to the manslaughter charges, but an inebriated person can form an intent. It is up to the jury to determine the degree of intoxication, to what degree the intoxication impacted intent. Here, he was not.
Is it your position that he could have been too inebriated to form the intent to kill, but he might have not been too intoxicated to form the intent to cause serious physical injury?
Yes, absolutely.
And what do you base that on?
For example, one could think of a bar brawl where somebody could intend to hurt someone, but not intend to kill someone.
No, I understand that there could be a different level of intent, but if the lack of intent to kill someone was based on intoxication, could the defendant nevertheless, notwithstanding that level of intoxication, still have an intent to cause serious physical injury?
Well, that would be a question for the jury. And there are various levels of intent the intoxication can impact intent. That's a question for the judge.
As opposed to a justification defense, which is non-criminal.
Correct.
Once you find justification, that's it. Everything else, all the lesser included offense falls.
Absolutely. And then rather than just make a blanket statement, just looking at the specifics of this case here, there simply was no reason for the jury to find that he was so intoxicated. I mean, basically his claims of intoxication amounted to a bare assertion of intoxication. In his initial statement, before he had the time to manufacture his defense, he talked about 2 cans of beer and a can of Colt 45. He speaks clearly, articulately, no slurring, during his voicemail that he sent to Ms. Simpson in the wee hours of that morning. There's no indication of intoxication in his subsequent video statement.
And his own testimony. He testified at trial.
He did.
Right?
And
so this is anything that your jury has to look at.
Exactly.
But his video statement was 24 hours later, though, wasn't it?
I believe it was 18 hours after the murder.
It was at
midnight.
Also,
but looking at that video statement just goes to show how this intoxication defense was manufactured. That, the story keeps changing. I counted 5 separate times that the story changes. But relating to intoxication, he says that he was still drunk during his video statement. I believe your honors have seen that video statement. There's no indication whatsoever that he was drunk at that video statement. And the fact that he says that he was that he was still drunk, and then it changes, and then he's hungover, it just goes to show that he's basically making up claims of intoxication to avail himself to this defense.
So, Counsel, let's quickly pivot to the other argument about the charge that was improperly given, or at least defendant's argument that the charge was improperly given in terms of the deadly force versus ordinary force. What's your response to that?
the court properly charged the both defenses in the alternative. His intent does not end the analysis. It was a jury question regarding the degree of force defendant used. He wasn't entitled to ordinary force if the jury determined he used deadly force.
I don't think, excuse me, counsel, I'm having trouble with understanding the relationship between what you're saying and what the defense claims is the problem with the charge. The question isn't whether or not the defendant used deadly force. The problem, as I understood it, with what the problem that the defense identified with the judge's instruction is that it suggested that the victim had used deadly force towards him and that he was therefore justified in using deadly force in response. But nobody claimed that she used deadly force towards him. So why wouldn't that have led to confusion as the defense claims?
Because it was a jury question regarding the degree of force that defendant used. So the jury had to hear both instructions so it would know how to apply it, because he wasn't entitled to an ordinary force justification if the jury determined he used deadly force. The jury had to know both so they could have a complete understanding of the legal principles applicable to its determination. And furthermore, this imposed no burden on defendant. Even if the court could have offered a different explanation, defendant wasn't prejudiced by the way the court instructed the jury. It didn't dilute his theory of the defense. And furthermore, the justification defense was weak and implausible. He disarmed her according to his shifting narrative.
Counsel, this is Judge Singh. How about your adversary's assertion that it affected the credibility of counsel?
Absolutely not. Absolutely not. I mean, he was a zealous advocate, and he mentioned that they weren't suggesting that Ms. Beck had used deadly force against him, but there simply was no ground to believe that he was justified at all. He testified that he had already disarmed her of 2 knives. He had caused blunt force trauma to her head. There simply was no need to hold her neck for however long he held it.
Do any of my colleagues have any further questions? Okay, thank you very much, Ms. Aldridge. Mr. Weiner, you have 2 minutes in rebuttal.
Thank you, Your Honor. An intoxication defense is about the defendant's capacity to form criminal intent. That is how the defense works. So if the defendant is too incapacitated by his drinking and drug use to form the intent to kill, he is by necessity also too incapacitated to form the intent to cause.
That's really, justification is easier. I don't say it's easier, but once you find justification, that's not guilty. You have no criminal intent whatsoever. The intoxication defense is all based on degrees. I mean, you could be so drunk, yes, to not formulate the intent to kill somebody, but you might not be so drunk as to formulate the intent to actually hurt somebody. It's very, when you're dealing with intoxication defenses, there's so many degrees of where you're at in terms of your state of mind. And that's up for the jury to decide. That's a credibility issue, and that's for the jury. And the defendant actually testified at trial for the jury to make those assessments. Because intoxication is it's a nebulous concept. It's a gray area. So I kind of, unless you got a case that actually says intoxication is it's one and the same and it's done. I think it goes back and forth a little bit. And I didn't see a case that you cited that says that, unless I misread your brief.
Well, Your Honor, People versus Butler, which we cited in our brief, certainly suggests that. It is not the holding of the case, but it strongly suggests that, and it makes sense theoretically. And with respect to the justification, the point is that respondent cannot identify why the jury needed to be instructed about the circumstances in which Mr. Coachman would have been justified in using deadly physical force, as Justice Gesmer pointed out.
This is Judge Scarpula. I just want to ask you one question. Other than your statement that you thought that it made sort of the defense lawyer look weak, is there any other prejudice that are you asserting that without that charge he would have been found innocent?
Well, I think it's impossible to say on the record. I think with these jury charging issues, this court has been careful not to apply too harsh
So
a
then let me
harmless
just
error
ask,
standard.
other than the fact that you think that the lawyer having to say, we are not contending deadly physical, that he was justified in using deadly physical force, are you alleging any other prejudice?
Well, it's that and the potential for juror confusion. I think a diligent juror in this case who's listening to the charge.
Wasn't there a complete instruction about the difference between deadly physical force and ordinary physical force?
There was, Your Honor, but I think a diligent juror in this case is going to be listening to the jury charge and hear this long charge about, was the defendant threatened with deadly physical force, and under what circumstances could he be justified in doing so? And having followed along with the evidence, say, I'm confused. I thought that wasn't part of this case. I listened to the defense summation. I thought that wasn't part of this case, but maybe it is because the court is telling me it's important enough to pay attention to.
Well, isn't the defendant's lawyer telling the jury this is not part of the case sufficient?
He is, but the court is saying this is part of the case. You ought to consider this.
Oh, are you saying that the court told the jury it is part of? I didn't see that.
Well, I think it's implicit in instructing the jury on the defense. That is why the rule is that the jury ought not be instructed about defenses that have no reasonable basis in the evidence. It's to avoid speculation by the jurors. And that potential for confusion was highly prejudicial to Mr. Coachman in this case.
Okay. Any further questions? Judge Owen, did you have another question?
No, I'm fine. Thank you.
Okay. All right. Well, thank you, counsel, both very much. We'll take another look at that issue.
Thank you.
Thank you. Have a good afternoon. The next case is Noble Desktop versus American Graphics.
Good afternoon, Your Honors. I'm Ray Beckerman, the attorney of record for the defendant appellant. I request permission from my distinguished colleague, John Mangonis, a member of the Bar of the Commonwealth of Massachusetts, to participate in the appeal. We had made an application which was granted for pro hac vici, and we have both filed notices of appearance.
Yes, I am aware of that. Thank you very much for the introduction, Mr. Beckerman. Mr. Mangonis, you welcome from Massachusetts. You may proceed.
Thank you very much, Your Honors. And this case comes on appeal from the denial of a motion to dismiss for failure to perfect service. We represent the defendant, American Graphics Institute, and there were 2 service attempts on American Graphics. The first, well, I should start that the case was filed on December 1st, 2020, and then on December 16th, there was a service attempt under CPLR 311-A subsection A, in which—
Counsel, this is Judge Owen. I got to ask you a question. Why is it then, unless I read the record wrong, why is it that your client terminated the services of the agent who is authorized to receive service like a day before a motion to dismiss was made? Did that happen, or am I reading the record wrong?
That's outside of the record.
I don't think it was outside the record. Why I don't do independent research? Trust me, I got enough work to do than to go outside and start researching independent records.
I don't know the answer to that question, to be honest with you. It came after both service attempts. That
no, but it came. But the term that do you dispute that there was a termination of the agents for service in Massachusetts? Or it was an attorney over there.
There was at least a change. I know that.
He got, according to the record, he got fired a day before the motion to dismiss came down.
It's quite possible, yes.
It's a little coincidence there, but okay, I got it. Thank you.
Counsel, this is Judge Singh. I can agree with you that you have good arguments with respect to the first service. With the second service, I'm not sure, sir, as to whether or not that was good. But in any event, the court here granted a cross motion and extended the time to serve. Isn't that really what the focus is? If that extension was granted properly, then all the other issues can be resolved down the road.
So that is really what I primarily wanted to address today, which is in the event that this panel does assign error and find that there's been no service effective, what should be the action going forward? And I would say that it has to be dismissal, and the reasons are this. Number one, It's been over 14 months now since this action was filed without any service being accomplished. And service was never
Well,
hard
but
to.
it's
Counsel-
interesting. I'm sorry, go ahead.
Go ahead.
It's just as my colleague was pointing out, the record is kind of murky. You have someone appointed for service, your client terminates that person. So there's an appearance, and we've all been trial court judges, there's an appearance that your client is simply trying to duck service. And that's not something that we in the courts of New York accept. Obviously, there has to be service in accordance with the CPLR. So in these circumstances, again, isn't there a good cause based on the firing of the person, et cetera, for there be a 90 more days to get service accomplished?
Okay, so I would say, first of all, there was a motion to extend service time that only went until April 19th, 2021. So there might need to be an entirely new motion for a request for an extension of time to serve. So that's one issue. The second issue I would bring up that I think is worth considering is that if service is to be completed in the future, meaning a date in the future from today, then that is going to raise some issues with what's gone on in this case so far, which is that there's been a preliminary injunction, which now will have entered in a time about 10 months ago where service had not been completed. And then there was subsequent to that, there was a motion for sanctions for violation of that injunction, which we've opposed and which was heard contemporaneous with the motion to dismiss and has been maybe 7 months pending in the decision, which if that is...
Counsel, this is
Counsel,
I just want to ask you, I'm sorry, one question. Do you dispute that the plaintiff has tried, I mean, really tried a number of ways and times to serve you?
I would say that service has always been quite easy to accomplish. All they had to do was
The question is, so the question with the extension is always, has the plaintiff tried to do it and just been unable to do it? And then if that turns out to be true, we automatically grant an extension. So my question to you is, are you claiming that the plaintiff hasn't tried to serve you?
No, I've never claimed that.
Right.
So as long
as the plaintiff has tried in good faith to serve you and, you know, gets an affidavit from a sheriff in Massachusetts that says that service is proper, now later you dispute that the woman who you agree took the process isn't authorized to do it, but you're not saying they didn't try. And then they served again and they served the Secretary of State. And then they have mailed to you in certified mail a copy of the summons and complaint. So it may be, I mean, who knows? But it could be that service, you're talking about subsequent motions, but that second service could be good. So the only question really is, was it an improvident exercise of discretion to do the extension? And you've admitted they've tried to serve you. So I don't know why it would be improvident.
Why would it be improvident to do what?
To extend the time to serve you.
No, I don't necessarily.
Trying. No one doubts that they have been trying to serve you. It's not like they're messing around. They hired the sheriff. They've done a lot of different things to try and get you.
Counsel, let me follow up with that. We have a strong preference for deciding cases on the merits, as you do in your Commonwealth, where I'm also actually a member of the bar. So ultimately, there was no statute of limitations issue here. What is gained? I mean, if eventually they're going to serve your client, what is gained by all of this?
Well, for one thing, I'll say, you know, I have a client who, as this is a defense that he possesses and it's his right to push it forward. And so, and I've advanced it. And I think in this case, they have not served him. The rules are fairly easy to follow. And in this instance, there was actually a grant very early on of the ability to serve pursuant to 312A. Just simply by mailing.
So
and
you don't disagree with me that there's no statute of limitations issue and that ultimately this case could get decided on the merits somehow when you were eventually served?
No statute of limitations. These are just contract claims with, I believe, 6-year statute of limitations if it's the same as.
So all that you're gaining by litigating about this is a delay and when this issue will actually be determined. Isn't that right?
No, I think it's more than that, because we're going to have what's going to ultimately be an appellate issue on this injunction matter, because regardless of whether or not service is perfected in the future, the injunction will have issued at a time where service had not been completed. And so if there is found to be a violation of an injunction at a time where service had not been completed, that's going to be a different separate appellate issue.
Okay, we're going to hear from the other side, and you'll have 2 minutes for rebuttal, okay? Mr. Ray, for the respondent. Good
May it
afternoon.
please the court. Good afternoon. My name is John Ray. I represent the plaintiff respondent, Noble Desktop NYC. I think that a number of the justices have put the finger right on the issue here. On August 20, 2021, the Supreme Court denied defendant appellant American Graphics motion to dismiss. Instead, it granted Noble's cross motion for an extension of time to complete service under Section 304 of the Limited Liability Law. But it didn't state how much time it was granting. It didn't do that because it found that the prior efforts, the extensive prior efforts of service, were sufficient under 304, which is in part what's being challenged here. But nonetheless, service was completed, and the court can take judicial notice of that fact. It's right in the record in the trial court. It's docket entries number 97 through 99, where I filed an affirmation of completion of service.
So,
It's in the
counsel,
record.
this is Judge Scarpullo. Let me ask you that. Under the LLC law, correct? You served the Secretary of State, and then
Yes.
subsequently you mailed on certified mail, return receipt requested, and you filed that, correct?
That is correct.
I saw that
It is-
in the record, and that would, I mean, I don't know that the defendant has an opportunity to have challenged that service. That's the only issue. But assuming that, but that service was done.
Oh, and let me be clear. It was done before the notice of appeal was filed. So they clearly had an opportunity. They saw it. And quite frankly, the notice of appeal was filed that day.
But except it wasn't part of the original motion, right? That's the problem here. Okay.
It was part of the request for an extension, and the
Yes,
issue was
right,
we'd
right,
only
right.
requested.
By that time, after the lower court decided the motion, she didn't have that piece of information, that second part of it
Right.
before.
No,
Got it. Okay.
She granted an extension of time to
Right.
complete service. She
Right.
did not provide a time period. And so I think at most what they're arguing is you should remand. So she modifies her order to say Noble shall complete service within 30 days of the date of the order, which is in fact what we already did. If there are questions, I'd be happy to answer them with respect to the evasion, with respect to the issue of how within 4 minutes of an affidavit being filed in opposition, they terminated their agent. I'm happy to answer these issues. The evasion here is just beyond belief.
Oh, I'm glad you said that, because I was worrying that I was reading the wrong records.
You again, as I said, you all hit the nails right on the head, that this is just a pattern of evasion by these defendants who are trying to get away with it when there's no statute of limitations issue. This is going to proceed. The only point is to try to evade the issue of whether they violated the preliminary injunction that was entered against them and whether they should be subject to sanction. That's what they're trying to get rid of here, nothing else. This case is a pretty simple case of service that was completed, an order for an extension of time that was granted. She should have said, you have now 30 days, but we did it anyway. This is an open and shut book case, in my opinion, but I leave it to you to decide. If there's any questions, I'd be happy to answer, but otherwise we'll surrender the remainder of our time and rest on the arguments presented here and in the brief. Thank you so much.
Okay, anybody else have questions for Mr. Ray? Okay, I think you made your point loud and clear, Mr. Ray. Thank you. Mr. Mangonis, you have 2 minutes to respond.
Okay, very briefly, I did want to address that final service mailing attempt. I did address this in my reply brief, but that would actually come well outside of the bounds of even the extended deadline to serve, because the motion to serve requested a 60-day extension, which carried through April 19th, 2021. The court actually granted that, nunc pro tunc, finding that a service attempt that fell before that deadline, the service on the Secretary of State, had been completed. So when Attorney Ray served, after the argument, that would have been outside the bounds of what had been extended to him already as the time to serve. So I don't think that the court is ultimately going to find that to have been what completed service. The bigger question, I think, as this panel has homed in on, is why not just remand for an additional time, and they can do this once and for all, and then we can all go forward. I would say that is effectively tantamount at this point to simply dismissing the case and having them refile. And in the latter case, it would simply just avoid a potential different appeal over what to do about a preliminary injunction and a potential violation of that at a time in which the AGI had not been served with the complaint. So I think it just creates a cleaner record to dismiss and have them refile, and it will effectively put us in the same position.
Counsel,
actually, what it will do is then get you off the hook if you violated the injunction, right? That's exactly what a dismissal will do. Right? Isn't that really why this is followed at this point?
But we might be off the. First of all, genuinely, there are arguments. There's a reason she hasn't.
Absolutely. I have no idea what, right. But that would just take care of that whole problem right away, right?
I would say that we're off the hook for that anyway, because if this court allows them to serve 30 days in the future, 60 days in the future, that doesn't change the fact that we weren't served at the time that we had the injunction and the time that we were purported to have violated it. So how can we violate an injunction at a time where we hadn't even been served with the complaint?
Okay, I think we got the point. Both of you, thank you very much, and have a nice time in Massachusetts. The next case for oral argument is Moser versus the Transit Authority. We will hear from the appellant first. You have 5 minutes.
Thank you. Excuse me. Thank you, Your Honor. It's Tim O'Shaughnessy from Transit. Plaintiff didn't make out a prima facie case for a number of reasons. First reason is 2 cases from this court, which we cited in our brief, that hold that when the plaintiff is the only witness to an accident, the plaintiff should not be granted summary judgment, and the plaintiff's testimony should be evaluated by the jury. Plaintiff here had no response to those cases in his brief.
Well, counsel, this is Judge Singh. Is it that simple here? It's an unwitnessed accident. We have photographs. We have an expert's opinion with respect to the condition, etc. This is really not those cases, is it?
Well, we believe it is. The photographs are just of the plaintiff sitting on the stairs.
Well, what about the photographs of the pipe above? I mean, him sitting on the stairs is really not, I don't think, that relevant, although that was helpful. But we have the photographs of the pipes above and the corroded nature of that pipe, and that's really what they're claiming caused the accident. That's what we want to have photographs of.
Well, he slipped. The plaintiff slipped on probably the first, maybe the second step from the top. But he testified explicitly that he was not looking down. He was looking straight ahead. He did not see what caused him to slip. And he ended up sitting on the second step from the bottom.
And did he feel any conditions when he was on the ground?
Yes, he said
it was wet. So that takes care of that issue, doesn't it?
No, that only shows us that the step he was sitting, he said his pants were wet, so that shows that the step he was sitting on, the second step from the bottom was wet, does not show that the top step was wet. And furthermore, he's sitting there leaning forward, and he said that the leak was dripping on him. So if it was dripping on him, it could not have been dripping on the top step.
Well, sir, you know, it's not like a very long, like 25 steps. The stairwell that he fell on, because I looked at the pictures, there's just like four steps. So it could be dripping on the second and third steps at the same time. He was bending over. I mean, I don't see how that makes
Yes,
it
but those are,
impossible.
those are not, excuse me, I'm sorry. That's not where he slipped. He slipped on the first step down. Furthermore, our
But it could also be if it dripped on the lower step, that with people going back and forth, that the moisture would be carried up the steps as well as down. So it's not at all inconsistent with his testimony.
That's absolutely speculative, Your Honor. Plaintiff did not establish that there was an accumulation of water on the top step. He did not testify that he saw an accumulation of water down below the leak. Furthermore, the photographs that the plaintiff himself put in the record show that there is a drain right at the base of the steps on the mezzanine level. And our expert put photographs in the record showing that he went to the location and used a plumb bob hanging straight down from the crack in the overhead beam. And that showed that the crack in the overhead beam is about 6 inches from the bottom step, so that the water would be landing on the mezzanine itself next to the drain, where plaintiff did not testify that there was pooling, and he did not testify that there was pooling on the step, the top step that he slipped on. The plaintiff's expert's testimony is completely speculation and without foundation.
Do any of my colleagues have any further questions for Mr. Shaughnessy at this point? All right, Mr. Shaughnessy, you have 2 minutes for rebuttal after we hear from Mr. Isaac. Okay, Mr. Isaac?
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. There's far more here than just the plaintiff's testimony. This isn't an unwitnessed accident. You also have a video, which I'm sure you've taken a look at. The video actually shows him with what I think is an open fracture, sitting right on the, I guess, third and fourth steps.
Well, Mr. Isaacs, the point your adversary makes, and that's what I want you to address, is, hey, the slip was higher up where there's no water. That's the point I want you to address.
Okay, so I would ask you to look at the expert's affidavit, our expert's affidavit, and their expert's affidavit. Mr. O'Shaughnessy is a very skilled lawyer, but he's making a claim that we're not making. If you take a look at the photos, you take a look at the video, you take a look at the expert's affidavits, there's testimony, undisputed testimony, that there's a drip coming down from the top of this bulkhead. You saw the photos of the bulkhead. It's open, it's rusted. Our expert said it existed for years, up to 10 years. Their expert says nothing about it. And what you see is, when you look at the photos carefully, and if you look at the video, the first 35 seconds of the video is great. Right around the base area of the stair, there's wetness. If you look forward toward the mezzanine, there's no wetness at all. It looks like it's in almost pristine condition. And the testimony not refuted by the transit authority is that the corridor leading from the big stairs on 42nd and 7th, to which leads to this 4-step stair, was also in pristine condition. We also know, Judge Singh, that the transit authority's own, what do they call them, NYCTA service call reports, okay, it's on 344 to 378 of the record, shows that on 3/9/13, there was a notation specifically that there was leaking from this bulkhead coming down. That's on 359 of the record. And 363 of the record shows that there was ceiling condition leaking from ceiling mezzanine. That's exactly the situation. There was a recommendation on the third column over that masonry work was needed and caulking work was needed. And it doesn't show that it was done. So what we have is a situation where we establish prima facie entitlement to judgment as a matter of law, and the defendant's opposition didn't rebut anything that we said. Their expert said that the plaintiff's version of the accident was incorrect because the leak could not have occurred on the second step from the top, but that wasn't plaintiff's theory. And in fact, if you look at what the expert said, he said it twice, 381 to 382 and 383. Other photos of the entrance egress corridor leading from the street to the subject stairs indicate a dry working surface. Therefore, ponded water on the mezzanine floor and the first step came directly from the deteriorated ceiling above Water on the upper steps was tracked up as indicated by footprints from the photographs, as well as directly dripping onto the first step from the mezzanine.
How do you respond to the affidavit of the Transit Authority's expert that using the plumb bob showed that the water couldn't have dripped from the corroded part to where he claimed to have fallen?
I think that his theory is actually consistent with mine. If you look at the photographs that he took, and especially the little ruler measurements, Justice Gesmer, he says that it could have been at the base of the first step and then the top, I guess the first step going up. That is completely consistent with what our expert said, that if this drip is continuing, people walking up and down will track that water there. And I think that the fact—
Mr. Isaacs, that's not speculative as your adversary argues?
The answer is no for these three reasons, Judge Singh. One, we have testimony undisputed that plaintiff saw the water dripping. I would also ask you, if you could, to take a look at the video, specifically the first 5 seconds. You know that there are two, I guess, EMS workers. If you look in the first 5 seconds, one EMS worker who's not involved in treating the plaintiff actually points up, looking at the bulkhead, and the second EMS worker, this is the EMS worker who's not wrapping the open wound, he looks up right at the bulkhead area. That's supportive of the plaintiff's testimony, as well, Justice Singh, as the additional evidence that the area beyond that first step, at the bottom of the step, is actually clean and not wet, and the fact that the stairway leading down to the steps is also not wet. So circumstantial evidence isn't inferior to direct evidence. Sometimes, as you noted in Caraballo against Paris Maintenance, it's actually better. This is a motion that can be decided on summary judgment procedurally. We established prima facie entitlement to judgment as a matter of law. Transit Authority did not controvert our showing. If there's nothing else, I'll rest on my brief and I'll let Mr. O'Shaughnessy talk to you in reply. Thank you.
Thank you very much. Mr. O'Shaughnessy.
In opposition to the motion, or actually as part of plaintiff's motion papers, was the testimony of Cleaner Chen, who testified. Of course, she came later, but when she got there, the stairs were merely damp. She did not see any accumulation of water. That alone is enough to create an issue of fact on a summary judgment motion. Furthermore, as we asked in our brief, we think that this court should search the record and dismiss the complaint because there is no showing that Transit had notice of an accumulation of water on the first step from the top. Plaintiff has gone to great lengths to prove that there's an overhead beam with a crack in it and rust. And even if we were to assume that Transit has constructive notice that water was leaking from there, we have absolutely no document showing that Transit had noticed that that was resulting in an accumulation of water on the first step from the top. Furthermore, the learned counsel for the plaintiff said that March 19th, 2013, there's a record that there was a leak to the bottom of the stairwell. That's not our stairwell, it's another stairwell. And in addition, the record of May 20th, 2013 was that there was a leak by the booth. It doesn't say anything about being near our stairwell, and it also says that the leak was caused by skylights. So therefore, not only should the summary judgment motion be denied, but the complaint should be dismissed.
Okay, you didn't cross move, right, for that relief?
No, we're asking the court to search the record on appeal.
Okay. All right. Well, thank you both very much. Appreciate the arguments this afternoon.
Thank you, Your Honor.
Next case for argument is Wesco Insurance versus High Rise Steel. The appellant, Mr. Savastano.
Yes, Your Honor.
Okay, good afternoon. You may proceed.
Good afternoon. May it please the court. I am Gennaro Savastano from LF Taratis and Panic for defendant appellant Samuel Sumplice. Your Honors, we're respectfully seeking reversal because the record here raises myriad questions of fact, and we submit that it was error for the court not to view this record in the light most favorable to us and to grant us the benefit of drawing inferences in our favor as the non-movement.
Counsel, I have a question. Counsel, this is
Yes,
Justice Gesmer. I have a question. Even if we were to find that on some theory that the driver and that this accident was covered in some respect by the policy at issue, why wouldn't summary judgment for the plaintiff be appropriate given the record of the failure to cooperate of the company and the driver?
Well, Your Honor, that is actually speculative. So I appreciate your question because it raises an important point. You can't find that he wasn't cooperating without first that the operator of the vehicle wasn't cooperating without first finding that he wasn't an insured who had a duty to cooperate under the cooperation
Well, I think
clause
the
of the policy.
question was, the caveat was, assuming that there's an issue with respect to coverage, why wouldn't the defendant's latter argument be a strong argument for summary judgment? So
Well,
let's assume for argument's sake, there's an issue of fact with respect to coverage.
Sure. I mean, their burden as the move-in would be to eliminate questions of fact with respect thereto, right? We don't know on this record whether Amran Twizer was operating with the consent of the owner.
Well, no. We're suggesting that you assume that he was operating with consent and that he was insured. Assuming that he was insured, why wouldn't summary judgment for the plaintiff be appropriate because of his lack of cooperation, their lack of cooperation?
Your Honor, your point is well taken, and I understand. But under these circumstances, it would have been improper to disclaim on that basis 4 years into the litigation. Essentially, everyone was operating under the same premise. Twizer was driving with the consent of the owner.
Wait a second, counsel. This is Judge Scarpula. Is there any dispute that the driver didn't show up for his deposition?
Nobody disputes that, Your Honor, no.
Right, he didn't show up. And then there was an order of preclusion based on his failure to show up, correct?
That's correct, Your Honor, absolutely.
So, I mean, that to me seems classic disclaimer for non-compliance with the duty to cooperate, and you can't disclaim until you actually get the guy actually doesn't show up. So the fact that it's however many years into the litigation, why is that even relevant? Everybody agrees he didn't show up and there was a preclusion order, correct?
Your Honor, you're absolutely correct. And the thing is, that was known to Wesco in January of 2016, about 1 month after the accident. Rather than raising that much as a basis for disclaimer.
Wait a second, 1 second, counsel. You're saying that he didn't show up 1 month after the accident?
No, the basis of the breach of the cooperation clause was that he didn't drive without a license. So if they were going to disclaim for that purpose, they certainly could have done so in January rather than waiting.
No, I thought it was because he didn't show up for his deposition.
I think there was more than one basis, but if you're going to disclaim for those purposes, that was one of their bases. It invalidates at least one of their bases. So wait a
second. Can I just ask you one more question, please?
Certainly.
Are you saying that it would be improper for them, after he doesn't show up for his deposition, to disclaim based on non-cooperation?
I'm sorry.
Are you arguing that it would have been improper for them, the insurance company, not them, the insurance company, to disclaim coverage after on the basis of failure to cooperate, after he didn't show for the deposition and there was a preclusion order entered? Are you saying it would be improper for them to disclaim on that basis?
Well, no, I'm saying that under these circumstances, if they were to purport.
What circumstances are you talking about?
Your Honor, here we have presumably a worker.
Counsel, this is Judge Owen. I'm going to throw you a bone. We got an issue here about whether or not there was cooperation. Supreme Court never reached that issue, correct?
Correct, Your Honor.
Okay, so that in my mind, the threshold, the key issue here is coverage, because the Supreme Court found in its decision that there was no coverage, right?
Correct, Your Honor.
Okay, so what is it? Can you argue then? Where is it then in the record to demonstrate that the policyholder here did not own the truck, because the accident report and the documents indicate that the truck was insured by Wesco. So where is it that where can you point to? How does the insurance company come to the conclusion then that it's not owned by the policyholder?
Your Honor, they hired an investigator who disclosed to them in 2016 that there were something like 5 shell corporations, all of which were controlled by the same principal. They reached out to that principal, who did not deny that the owner was driving with his permission. The phone number that the driver placed on the police report was actually tied by their own investigator to that principal. So it's certainly inferable under this record that he was driving with the consent of the owner. Now, you know,
So that goes to the issue of coverage, okay? That goes to the issue of, I still haven't heard an answer to Judge Scarpulla's question with respect to cooperation. I mean, that relating to the driver's failure to show up at the EBT, where the court then issues a preclusion order. It's that, not pre-litigation, but the litigation aspect.
I understand, Your Honor. Well, our position is that it would be inequitable to do so under these circumstances, after lulling us into a false sense of security for 4 years.
But counsel, as Judge Scarpulla pointed out, until the driver doesn't show up, they're in fact providing a defense. They're acting like an insurance company should act by providing a defense. But when the driver doesn't put up and they can't establish a defense, why can't they disclaim for lack of cooperation by the driver,
Your Honor,
during litigation?
They can. It's a pretext, and that's evident. They can and they did. It's a pretext, and it's evident by the fact that it's not the only basis upon which they disclaimed. And you know, they're looking for a reason to get out of the preclusion order. I understand it, but they knew the policy language from the beginning. They knew a basis for breaching the cooperation clause since at least January, when they received the police report and they were notified of the accident.
But, so you're telling me that they knew that the driver was not going to cooperate and show up for an EBT, a month after the accident?
No, I'm not arguing that they can see the future reports.
But you're not addressing the question that we're asking, right?
No, Your Honor, what I'm
saying
saying
that there are other reasons to where it could have been terminated for failure to cooperate based on what the principal did and what the investigation. But I'm asking you to focus, or Judge Scarpulla is asking you to focus on the litigation aspects and the driver's failure to appear for the EBT.
Well, I'm not arguing that it wouldn't be a legitimate basis. I'm arguing that under these circumstances, it would be inequitable, and that the disingenuousness of their conduct is evident on this record, and that this court should equitably intervene. If not now, when? I think there's, yes.
I have another question, but I didn't mean to interrupt you. You can finish your answer to Justice Singh first.
I was finished, Your Honor. Thank you.
Okay, so I have a question about the investigative reports. Is it your position that the investigative reports attached to Mr. Appman's affidavit are properly before us and that we should consider those in determining this?
We did argue that the Appman affidavit did not lay a proper foundation, but even if you were to consider them, they raise more questions than answers, and so they undermine defendant's position. We don't believe they've met their prima facie burden, but that their own submission.
Is it your primary position that we shouldn't consider the attachments to his affidavit?
Yes, Your Honor.
Okay.
And what's the what's the basis for you reaching that conclusion?
Well, if he had so much familiarity, there's no basis of familiarity for reviewing the records or speaking to his colleague. But if he had so much familiarity, he would have known the policy language upon which he relied 4 years later to disclaim. So, you know, it's an alternative argument. And I understand that the court wants to consider it, but I would ask the court not to do what I think the court below did, which was to ignore those portions of the record that didn't support the conclusion and not view it in the light most favorable to the non-movement.
Okay, we've given you twice as much time.
I
So
apologize.
that's not your fault. We had a lot of questions. And that's why we wanted to, we don't have to follow the light, not the light, but the time. So thank you for your answers. We're going to hear from the other side and we'll come back to you for 2 minutes for rebuttal. Respondent, you have 5 minutes.
Good afternoon, Your Honors. Max Gershwire for the plaintiff, Wesco.
Mr. Counsel, this is Judge Singh. Yeah, I reread your brief again today because this case has been a problem for us. I will admit. Your position in your brief, and then you cite to the record, is that the truck was owned by High Rise Steel, correct?
Correct.
What proof is there in the record that High Rise Steel is the owner of the truck? You cite to record pages 75, 76, correct?
Let me see.
75, 76 is a registration.
Right.
Is a registration statement proof of ownership, or aren't title papers filed with the state as well? Wouldn't that be more indicia of proof of who owned the truck, especially in these murky circumstances?
Your Honor, this is not an issue that my adversary ever brought up. I believe the registration is.
Well, it goes to your prima facie, right?
I understand, but I believe that we, I think we satisfy the prima facie burden by submitting the registration certificate. We also submitted the.
What does the registration certificate show?
It shows that the owner is High Rise Steel.
But counsel, then how do you justify the fact that the truck was listed on your insurance policy as a covered vehicle? Doesn't that create a question of fact, at least, as to whether or not this was the automobile and its driver were insured by your policy?
Well, Judge, clearly what happened was that the applicant it's not the insurance company's burden to make sure that the what's in the application is accurate. The insured submits.
I thought that insurance companies checked on the veracity of applications all the time.
No, Your Honor.
So your position is that you don't have to, you have no burden. The fact that you listed it in your insurance certificate as a covered vehicle has no implications?
That's right, Your Honor, because again, the insurance company is entitled to rely completely on the application submitted by the insured. Again, that's not an issue that was brought up, but that is clear. That's black letter law. An insurance company is not required to make sure that the information that's contained in an application is true. They rely on the information and they issue the policy as appropriate. So clearly what happened was this person who's been juggling these corporations decided not to submit an application on behalf of High Rise Steel because they had a claim history, and that which would have resulted in either the application being rejected or a higher premium. So he creates these new corporations, says that they own this vehicle, and so the insurance company relies on that information and issues the policy accordingly. So there's nothing wrong with how Wesco submitted the policy or wrote the policy, but they were relying completely on the information that was provided by the insured.
So apart from the registration, which does not on its face show ownership, what do you rely on to show that this vehicle was not owned by the insured?
There's also the police report, Your Honor. So obviously,
but a police report doesn't. That just reported on.
Well,
the policeman probably looked at the registration. That's not independent evidence.
Sure, it's the registration, but there's no. I mean, I guess I'm a little flummoxed by what proof would be required to show.
You're saying that even though you listed it on as a covered vehicle, that in doing so you relied on the representation that it was owned, and now by the insured, and now you're saying it wasn't owned by the insured. So you're the one who's raising the fact that it's not owned by the insured. And the only documentation that you're claiming supports that is the registration, which in fact doesn't say anything about ownership. So apart from the registration, what evidence do you have that this was not in fact owned by the named insureds?
We only have the registration, Your Honor. That's the information that we have. My understanding is.
But do you claim that the registration proves ownership? It only proves registration, doesn't it?
Well, I'm not aware, Your Honor, my understanding is that registration and ownership is evidence
So
of ownership.
in other words, counsel, if I'm to sell a car, the buyer takes the registration and that's it? Title has nothing to do with it?
No, but I believe the title.
That's just a rhetorical question. So I want you to assume the same question that we asked your adversary. I want you to assume, for the purpose of this question, that there may be issues of fact with respect to coverage. Does that still, can we still find for the plaintiff on the second issue, and that's with respect to cooperation, and specifically with respect to the driver's failure to appear at the EBT?
Yes, Your Honor.
And what documentation in the record shows that specifically?
It's the investigation reports that are attached to the affidavit from.
Could you explain to me why those investigation reports can be identified by Mr. Appman? The investigation reports are produced not by his company or by a company he's an agent for. They're simply letters from somebody else. How can he get around the hearsay rule as to letters produced by an entity to which he has by which he's not employed or the agent for?
Yes, Your Honor. Well, they're maintained in this. Obviously, investigations are a regular part of an insurance company's business. They hire.
No, but it needs to be created in the ordinary course of his business. I understand that when they're mailed to them, they hold them in the ordinary course of their business, but that doesn't show that that doesn't get around the hearsay rule in their creation.
I understand your point, Your Honor, and we, what is clear from the record
is that accurate, Counselor? Counselor, can a third party have a business duty here, especially an investigator retained by an insurance company, to report accurately? And then can the insurance company rely on the records created by the entity that it retained to do the investigation?
Yes, Your Honor. I mean, I think that's a good point. Insurance companies sometimes use employees, sometimes they use third parties, but it's really there's really no substantive difference between how that is investigated.
Are you arguing, for example, that this is like your accountant who does your billing, and then you get the billing information, and that becomes your business record on the same sort of theory?
I believe that's a good analogy, Your Honor. Again, investigations are what exactly insurance companies do when they receive claims. So that is certainly
Counsel, do you have any case law that supports that an employee of an insurance company can introduce as his own business record an unsworn report from a third party whom he has hired?
Your Honor, I have no such case law at my fingertips. It's not an issue that was raised. If I may, with my limited time, may I just...
It was raised by defense counsel, as Mr. Savastano said. They raised the issue of whether or not it was appropriate for us to consider the documents attached to Mr. Appman's affidavit.
Right. Well, we were focused on the insurance policy, which was the only document that was necessary to establish the lower court properly found that there was no coverage.
Well, counsel, okay, but you haven't answered my question. Going back to the issue of failure to cooperate, and specifically the driver's failure to appear for an EBT, is that an independent basis for Wesco to disclaim coverage under the cooperation clause?
Of course, Your Honor. I mean, the insurers are obligated under the policy to cooperate in the defense. Obviously, appearing for a deposition is a critical component of that. So yes, the failure to...
Now, Supreme Court didn't address the issue, correct?
That's correct, Your Honor.
Just address the issue of coverage. What would be the appropriate procedure? Should the case be remanded to Supreme Court to make a determination on the failure to cooperate, or is that something that we should do here?
Your Honor, my understanding is that the court can search the record, and if there's an alternative basis for affirming the order,
then... Well, it's not searching the record, but the argument's there. I'm just asking you whether this should be remanded to Supreme Court to make that determination, as opposed to us making the determination.
We would argue that the court is empowered to decide that issue because it was addressed in the record. So that we don't believe that it would have to be remanded.
And let me just make sure I understand. When you say it's addressed in the record, you mean in the documents, the so-called investigative documents and letters attached to Mr. Appman's affidavit. Is that right?
That's correct, Your Honor. If I may briefly,
well,
Your Honor.
You don't have any more time. You also have, we've given you twice as much time.
I understand.
So,
can I just
I think the fact that you answered all our questions was what we needed. We obviously had a lot of questions, so and have read the record. So I'm going to allow the appellant 2 minutes for rebuttal and any further questions we may have for Mr. Savastano. Thank you, Mr. Gershwire.
Thank you, Your Honor. I'll take less than 1 minute. I just want to point out to Justice Singh's most recent point about whether there should be remand or whether you should search the record. Under the Hartford case, which we cite in our brief, 46 NY2D at 1030, the propriety of disclaimer, the timeliness, the reasonableness is a question of fact. So we believe that it warrants denial of the motion. And unless you have any questions, I'll rely on the briefs.
Any further questions, colleagues? Okay, well, thank you both very much for answering our questions, and have a good afternoon.
Thank you, Your Honor.
Thank you, Judge.
The next case for oral argument is Payne versus NSH Community Services, Inc. The appellant, let's see, you have yes, you have 4 minutes, I guess, 4 minutes and 1 in rebuttal.
Thank you, Your Honors. Good afternoon. Beth Rogoff-Gribbins for Defendant Appellant Respondent Peter Scalmandrin. Mainly, the court erred in finding that this rebar mat that was solely installed to reinforce concrete that was going to be a ramp at the front of this parking garage was a de facto or functional equivalent of a scaffold.
Is that accurate, counsel? Is that what the court found? Didn't what the court find? There's an issue of fact as to whether this is really a gravity-related elevation differential case, and the testimony is inconsistent. 12 inches versus maybe 2 or 3 inches. Isn't that really the finding of the court?
I'm going to say yes and no, because the fact that the court relied on the industrial code provision dealing with the planking on scaffolds also shows that they did say that this rebar was a scaffold, but or at least the functional equivalent. But I also would like to address your point.
So what is the test? What is the test for determination of what's a functional equivalent of a scaffold? And we have case law. I don't think it's really addressed in the papers. Are you familiar with the test?
I am, and that was partially whether or not it's supposed to assist somebody to work at an elevation. And there is clearly no assistance to work at an elevation here. Nobody, not even my own clients, were working at an elevation.
So that goes to the 241-6 claim. But
Yes.
But still, with respect to, I guess, going back to the 241 claim under Brown, why wouldn't there be an issue of fact, not for a defective scaffold, but elevation-related risk that plaintiff sustained?
I'm so glad you asked that, because I would like to point out that this was not due to the force of gravity. This court has held
Wait
several.
a second. What about Ms. Rogoff? We have a case, Brown versus whatever.
44th Street Development LLC.
44th Street Development, and Judge Singh happened to be the trial judge on this, and I happened to be on the appellate bench on this. And it seems like a very, very similar case where the plaintiff was walking across a latticework rebar deck, which is exactly what the picture looks like, a latticework rebar deck, and he fell. There is some, the way I look at it, the latticework rebar deck was on blocks. I can't be exactly sure how high those blocks are. The plaintiff said 12 inches, the defendant said much less, or other witnesses said less. So maybe that's an issue of fact, which is what Judge Leibovitz found. But how do you win on that? I mean,
Well, first of all, Brown is very distinguishable. In Brown, the plaintiff fell through the rebar.
But his hands here fell. His hands here, he says they fell. I mean, I looked at it. He wasn't small enough to fall through the rebar, but his hands fell through and he reached the ground underneath. And that caused him to fall in an angle at which he claims he hurt his knee, I believe, and part of his leg.
In the case Landy versus SDS Williams Street LLC, this court actually, and I'm going to quote, the plaintiff's elevation did not proximately cause his slip and fall. It simply contributed to the distance he fell. Although the plaintiff's elevation at the time he slipped and fell may arguably have contributed to the severity of his injuries, it did not cause his slipping and falling. That is exactly the same as the case here before this court.
And how is Brown different than this case?
In Brown, first of all, number one, the plaintiff was required, absolutely required to walk across the rebar. Number two, he fell through, or at least
you
his
mean
foot.
to say that the plaintiff at Brown fell completely through the rebar mat?
That's why I said his foot
And
went
here,
through.
I'm sorry.
Here his hand fell.
Yes, but his hand didn't fall through because of the force of gravity. He tripped, I'm sorry, his trip was not due to the force of gravity. His trip was due to his toe getting caught on the rebar.
And then gravity affected him.
A place where he wasn't supposed to be in the first place.
Wait, excuse me, are you saying that a worker's not supposed to take a coffee break? I mean,
No.
if this was the only way he could get to the coffee truck on the 20 minutes of his coffee break, are you saying he was not supposed to be there?
Okay.
There's no indication in the record that he was told about any other way that he could get there in time to have a coffee break. Are you saying that he's not entitled to his coffee break?
I'm going to ask the court to remember who my client is. My client is a co-subcontractor. My client is not responsible to tell the plaintiff when there's alternate means of egress that he has to use. That was not my client's job.
Yeah, but your client's job was under the subcontract to lay a covering over the mat for obvious reasons, correct?
No, only when it must be traversed. In this case,
well,
it
in this
didn't have
case,
to be.
Isn't this at least an issue of fact about whether or not he had to? I mean, he wasn't really familiar with the area. That's how he says, this is his testimony, I believe, that that's how he went every day to his coffee breaks. All of a sudden he comes up, there's nobody around. He sees this rebar lattice work. He says, well, how am I going to get to the coffee truck? I don't know how to get around here. I'm not familiar with the area. Maybe it turned out that there was another way. He didn't know about it. He had 20 minutes. He started to walk and he fell. Aren't there doesn't that factual scenario create at least an issue of fact? It's not that it's not that the judge granted summary judgment, did he? No. It was just that he found that it shouldn't be dismissed, that there are issues of fact.
Again, my client wasn't responsible for letting all the subcontractors know when they needed to take an alternate route. That was not my client's job. My client's, if my client's rebar needed to be traversed, which is contrary to the purpose of the rebar, as the plaintiff himself testified, walking across the rebar degrades it. So it's contrary to their purpose. Now, the plaintiff did testify,
in other words,
and I have
every time that a worker has walked on rebar, I mean, there are reams of cases on this issue. So it's an issue that contractors are very familiar with, and presumably that's why the subcontract says cover it, especially in this case where it's near a means of egress, right?
But again, it only says that it has to be covered when it must be traversed. And that same provision is in the plaintiff's employer's subcontract as well.
But isn't there a question of fact as to whether it must be traversed? That's the issue here. If that's his only means of egress to have his coffee break, which it seems to me is part of a right of a worker to have one, then why isn't that a question of fact as to whether it must be traversed? And then it becomes a question of fact as to whether it was your client's duty to cover it so that it would be safe to walk across.
Okay. He testified he was aware of the other means. He was just upset, and he felt he wasn't given the respect he deserved by not being forewarned that the ramp was total rebar, which he did know when he left that morning that they were actually working on completing it, and they were almost done when he entered the garage. So he was aware that this was being done and that it was slated to be completed. But that being said, he testified. Only his affidavit says he didn't know the other means. His testimony was he was aware. Page 312.
Right, but none of those other forms of egress would have allowed him to get out of the building to the coffee truck and back in 20 minutes, right?
If he walked faster, if he had started off the route the right way in the first place, yes, it would have.
Okay, Ms. Rogoff, thank you for you've been answering a lot of our questions. You will have a chance to come back afterwards. Can we hear from NSH, please? You also have 4 minutes or as long as our questions take us. Thank you.
May it please the court, I am Martin Adams, counsel for NSH and Turner. I respectfully request that the branch of the order of the trial court that denied summary judgment be reversed and that summary judgment dismissing the summons and complaint on behalf of NSH and Turner be granted. I will answer the questions that your honors posed earlier. What is a scaffold? A scaffold under the Industrial Code definition 23-1.445, which is quoted in our brief, is a temporary elevated working platform. At the time at issue, plaintiff, an electrician, was not working on installing a fire alarm, which is what he was doing.
Well, counsel, let's assume for argument's sake, just that this is not it's not a functional equivalent of a scaffold. But again, isn't there an issue of fact? Plaintiff falls, whether it's a gravity-related height differential, isn't that sufficient to raise an issue of fact for the jury?
No, Your Honor. And first of all, not all gravity-related injuries constitute a violation of 240.
Well,
Secondly,
okay, but we have Brown here, right? Brown, I know you guys want to run away from Brown, but we have Brown here, which is very similar to this fact pattern.
I don't want to run away from Brown. I want to run towards it, and I will answer Your Honor's question. In Brown, rebar, both feet of Brown slipped through the rebar and fell 12 to 18 inches.
So the distinction is what body part falls through it. So that's what the appellate division is going to start doing, looking to see what body part goes through rebar to determine whether it's a 241.
No, Your Honor, just the opposite. If the body part goes through rebar, I don't care what it is. If it goes through rebar and hits the ground below, you have 240 under Brown. That's the big distinction in this case. Plaintiff himself claims a knee injury. His knee did not go through the rebar. It fell onto the rebar, as plaintiff himself testified. Plaintiff is also claiming a right pinky injury. According to plaintiff, the pinky caught the rebar, and that's what caused the injury. Your Honor, if any part of the plaintiff, and I don't care what part it is, went through the rebar and fell 12 inches below and contacted the ground, I agree, Brown applies. But that's not what we have here, and therefore Brown does not apply.
So, counsel, this is Judge Scarpula. I just want to make sure that I hear you right. It's your position that the plaintiff is not claiming that his hand injury is a result of falling through the rebar, but his hand injury is because it hit the rebar. Is that correct?
That's correct. The left hand, I tried to catch my hands on the rebar, and his right pinky struck the rebar. If his right pinky went through the rebar or any other body part went through the rebar and got injured, I don't care. It's a 240 case under Brown. That is not what we have here, and Brown does not apply for that reason. Accordingly, 240 does not apply. This is your standard, unfortunate trip and fall accident. But as the courts have noted, not all accidents that occur on a construction site in the course of a working day constitute a violation of 240. Therefore, the summons and complaint should be dismissed. 240 does not apply. I'll be happy to answer any other questions your honors have.
Anyone have any questions? Okay, well, you'll have a minute for rebuttal also, Mr. Adams. So, Mr. Feiner, can we hear from you, please? You're on mute, Mr. Feiner. And we can't hear
waited so
you.
long, I forgot to click it on.
Yeah.
Good afternoon, Your Honors. Brown is exactly the case that we're talking to.
Mr. Feiner, can you factually address your adversary? He says that, I guess what he's saying, what I'm hearing, is that no part of your client's body went through the rebar. Is that correct?
No, that's not true. Maybe one of his hands his pinky hit the rebar, which caused an injury, but the other hand, he testified went through the rebar, and it was that act of going through the rebar that provided him zero resistance.
And did it go through the rebar and hit the ground?
His hand went through the rebar, hit the sand or the ground about approximately 12 inches below. Because of that, because he had zero resistance to brace himself.
Judge Scarpula, may I just interrupt you for a second and ask you, is he claiming injury to the hand that went through?
Hand and his knee. This isn't just.
No, there's one hand that you hit the rebar, and he's
Correct.
claiming injury with respect to that. But that's not the hand I'm talking about. You're saying the other hand went through, correct?
Correct. The other hand.
And is he claiming injury to that other hand?
No, I don't. He's not claiming an injury or fracture to the other hand. What he's claiming is
So
because
then the injury couldn't have been caused
Yep. But
by him going through, right?
But
The
is-
injury that
isn't
he's
it
talking about is not an injury that was caused by gravity. It was caused by the rebar.
no, I'm sorry, Your Honor, Captain. I didn't know if you were
No,
talking.
that was Judge Scarpula that was talking, but I mean, I was just saying that doesn't Brown say that the issue is whether plaintiff's fall was the result of exposure to an elevation-related risk. If we find that it is, does it really matter whether it was his foot or his hand or his finger? If the fall was caused because his hand went through and it caused him to be put off, to fall, because if he'd been able to catch it, then he wouldn't have fallen, he wouldn't have hurt anything. I'm not sure if there's a case that says you have to hurt the part of your body that goes through the rebar opening. But, I don't see that. I don't see that that's what Brown says.
Yeah, you're right, and that's why I was trying to say that basically, I don't want to say irrelevant, but the fact that his hand went through rebar, went through and landed 12 inches below, did not give him the ability to brace himself as he's going down, and therefore his knees hit the rebar. It would be tantamount to falling through with your hand and hitting your face against the rebar. It's not that his face went through, but the accident ultimately happened because of this elevation in which he couldn't brace himself. In this court, I go back to Brown. When this court was looking at the trial court's Brown decision, the judge had mentioned, if I may, about the area being flush, that the rebar was not flush with the ground, and therefore it caused this elevated condition. So there was certainly a difference. There was certainly mention of the elevated condition. And again, as the court had noted, it's not a bright line test. And all I'm trying to get at today with my opposition is that there are questions of fact. I'm not here to argue dispositively on my end, but the judge did look to Brown as it's disseminated.
Counsel, with respect to 241-6, in your brief, you argue that the rebar is functional equivalent of a scaffold, correct? You don't really cite any cases for it, but your adversary is correct when I asked her what the test was, and essentially the test is this a device designed to protect workers from elevation-related hazards? Is it a normal appurtenance to the building? And in this case, the rebar is going to be filled with concrete, right? So is this really a functional equivalent of a scaffold?
It is, Your Honor, because again, based on the Brown decision and the appellate division's.
Well, Brown never really addressed. The appellate division at least never addressed that issue.
Correct. And yes, and what we're saying is that again, there is a functional equivalent when you have a height differential or an elevated height, such as the rebar here. And again, question for the jury whether.
So in other words, it's your position that every time there's a height differential, that's a scaffold? I mean, no, I don't think that's consistent with our case law.
No, when there's a question as to a height elevation, if this is a height elevation or a risk, then there should be a scaffold or the equivalent of a scaffold, which would this case.
This is Judge Ryan. I'm sorry to cut you off, but this rebar that was laid down, whatever height differential it is, ultimately that's the purpose of that rebar mat is for concrete to be poured over it, correct? To create a ramp.
Correct.
So how is that in any way? Could we say that that's either a temporary scaffold or even a scaffold? Because my understanding of scaffold is it's going to be removed at some point, but with this one, this rebar mat, it ain't going to be removed. The concrete's going to be poured into the rebar because the rebar is used to reinforce concrete. So how does this fall into a 241 situation?
Because Your Honor, thank you for asking the question. The rebar at that very moment was a height. There was a height differential. I got that.
But ultimately, that goes to 240. I mean, we're not on 240. I'm looking at 241 now. which is the
Right.
regulation you cited for scaffold. When we know, we just cannot get I can't get around the fact that ultimately that rebar mat is going to be a ramp. It's not a scaffold. So how does the regulation even apply?
Correct, but you know, when there is this rebar placed, and then it's left unattended by the entity constructing it, or the owner
Right.
or operator, and there is a known foreseeable other workers or other laborers.
So then
may
isn't
be-
that a standard negligence
That-
argument?
Yeah, there you go.
That is
Got
as
it.
well, yes.
Got it. Justice Kapnick is reading my mind.
I'm reading your mind there, Judge.
Well,
Point.
that is as well, yes. And again, there wasn't ongoing. I know 240.16 has to do with an ongoing work. There was no ongoing work at the time. It was left unattended. There was no actual literal work going on, and it allowed for a dangerous condition, which, by the way, there was a contractual obligation
To cover it in some way
Yeah,
if there is, but
and when we say, and I like Ms. Gibbons
Just
very much.
finish up.
Well, yes, it wasn't that a plank or a walkway should only be placed when there's a must, when there's a need. You can never tell when somebody is coming to walk over the area and then all of a sudden lay down a plank. They knew that there were other people using, or other entities using that area. So there was certainly, when nobody was there and it was unattended, that was the must.
okay, we're gonna, thank you very much. Ms. Rogoff Gibbons, you have a minute. So you
Thank
can
you.
respond to whatever you'd like, unless, of course, we have questions.
So I have a question
Oh,
for you. Do
there
you
you go.
agree with Mr. Adams that Brown applies if any body part of the worker touched the floor as a result of falling on the rebar?
No, I do not. In fact, that was the first thing I was going to address. As stated in the Court of Appeals case Nicomenti 25 NY 3D 90, that liability under 240 only applies when it is the direct consequence of an elevation-related risk, not an ordinary tripping or slipping hazard.
So,
This
so
was
in this case, the rebar is maybe 12 inches above the ground. That could be elevation. Could be an elevation-related risk. Plaintiff falls and goes through the rebar mat. Isn't that gravity related at that point? And he's injured.
Every fall is gravity related. If it wasn't for gravity, we would
Well,
never
but it's
fall.
elevation and gravity. Haven't both elements been satisfied? And isn't that what we found in Brown?
In Brown, that is not what you found. Again, it was the direct force of gravity that caused the fall. Here, he didn't trip because he fell through something. He tripped because his toe got stuck on the rebar. The same trip could have happened had the rebar been on the ground. Just like this court held in Landy, the only thing that the height differential did was perhaps increase his injuries, not increase the risk related to 240. This is not a
risk that
dangerous
he suffered-
activity.
Counsel, I have a question. Once he caught his toe and he then fell, he fell very differently because of the elevation, because his hands, according to the record, reached all the way to the ground 12 inches below, so that the nature of the fall was very different than if he'd been on a flat surface.
But that's the
Do you
same
agree?
thing. That's the same thing that happened in, as I said, Landy, Nicomenti, with these people that are walking on stilts. The stilts didn't cause the falls in those
This is not
cases. It wasn't
stilts.
gravity.
I'm sorry, Counsel. We're not on that fact pattern. We're walking on an elevated surface.
Well,
I'm
but
sorry, go on.
again, when you're dealing with an elevated surface, you also deal with the risk involved. What is the risk here? The risk is of him falling. This isn't a case where we've got a 2-ton thing that could topple at the same level. This is a plaintiff falling at the same level, 12 inches at the most. Okay, because in answer to Judge Kapnick's question, those are bricks that were under the rebar. Those bricks are about 3 inches high. Okay, but okay, even saying, giving it in the plaintiff the
Benefit of the
all
doubt.
the inferences, 12 inches. this is not the elevation-related risk, the dangerous activity that 240 has in mind.
Okay, thank you very much.
Thank you.
Mr. Adams, you have a minute also.
Respectfully, Your Honors, I did not say that every time a body part falls through the rebar, it's therefore 240.
Actually, what you did say, Mr. Adams, because I wrote it down when you were saying it, is that Brown applies only if a body part touches the floor.
And
excuse me, on the record at both 335 and 337, the plaintiff said that both of his hands touched the floor. So based on what you said, it sounds to me like Brown should apply. Well, you specifically said it applies if a body part touches the floor.
And that body part is the injured part that was caused by the fall.
Before.
Okay, let me be clearer. When a body part falls through the rebar, if that fall through the rebar caused the injury, then yes, Brown applies. Here, the body parts that plaintiff claimed are injured did not fall through the rebar. Therefore, the fact that plaintiff's hands went through the rebar is irrelevant and does not trigger Brown. As plaintiff said, I caught my right pinky on a bar, not because his pinky fell through the bars. He said, after the fall, my knees were on top of the rebar and I came to rest on the rebar. Therefore, this is all on the record and my briefs. Therefore, the fact that plaintiff's hands happened to go through the rebar is irrelevant because that elevation differential did not cause or contribute to any of the claimed injuries, unlike Brown. In Brown, the fact that the plaintiff's both feet went through the rebar and fell 18 inches caused his injury.
Well, this is why the labor law will continuously give the appellate division a business till way after I am no longer in the appellate division anymore, because no two cases are exactly alike. I think we got all your arguments, and thank you, all three of you, for answering all the questions that we had this afternoon. We appreciate that very much.
Thank you.
Okay.
Thank you.
Thank you all. Well, again, all right. So we've had lots of questions. Let's see. The next case is Moss versus Marymount. The appellant is Marymount, and you have 5 minutes. Good afternoon.
Good afternoon, Your Honors. Thank you. May it please the court. Maysheen Riccardulli, appearing on behalf of defendant, third-party plaintiff, appellant Marymount Manhattan College. Here, the lower court correctly found that Marymount met its prima facie burden on entitlement to summary judgment, but erred in ruling that Marymount failed to remove material issues of fact regarding 3 issues. 1, that the ladder should have been bolted to the lofted bed. 2, that Marymount should have known of an alleged bent condition of one of the hooks of the ladder. And 3, whether Marymount adequately inspected or trained its employees to inspect its furniture. We respectfully submit that none of these questions are material to the issue of Marymount's negligence and the proximate cause of plaintiff's injury.
Well, there was a fairly lengthy affidavit in expert affidavit from Mr. Ehrlich on behalf of the plaintiff, and didn't he go through in 10 pages why the fact that that the hook was bent and it wasn't properly hung on and it didn't reach the floor were all parts of the reasons that the plaintiff fell off of this ladder, and that since it was in a dorm room where kids live, happened that it was the mother that fell, that was a form of negligence on your part for not checking that out. You knew that those ladders were in the kids' rooms.
Your Honor, let me address each of those points one at a time. First, regarding the bent condition of the hook, there's no evidence in the record that the hook was bent prior to the plaintiff's fall. The record is clear that
I'm sorry. How much did plaintiff weigh in this case?
I believe she was 150 pounds.
So you're suggesting that her action somehow bent the hook? I mean, it seems.
Well, there's various scenarios how the hook could have been bent during the accident. One of which would be that it was as she was hoisting herself on the bed, it became dislodged. There's various examples.
Aren't those just issues for the jury to decide?
But there's no
how the accident happened, how the hook got bent, whether or not you're on constructive or actual notice.
The bend in the hook, there's no evidence in the record that the bend in the hook existed.
Well,
prior
when did they take
Oh.
pictures of accident sites before the accident? Never. So I mean, the daughter, I believe, testified that every time she would get on the ladder, it would she would hear it sort of hit the bottom because it wasn't hung correctly. I mean, I thought I heard that testimony. No.
There's the clinking of the ladder as she ascended the ladder is immaterial to the issue of whether the hook was bent, because the testimony in the record is that the feet of the ladder did not need to sit flush to the floor in order to be secure. The security of the ladder came from the hooks attaching to the bed. So the fact that you would hear a clink is not evidence that there was anything wrong with the ladder or that there was a bent condition in the hook that pre-existed the fall.
Well, what about bolting? Wouldn't that have been a safer way to secure the ladder by bolting it?
There's no duty to bolt a removable ladder. The fact is that the ladder was designed to be specifically removable. It was safe as it was designed, and it just needed to be hooked onto the side of the bed.
Except in this instance, there's evidence. Don't know when it happened, but that it was bent. So it suggests to me that maybe there were other things or other steps could have been taken, no?
Your Honor, just because it could have been bolted doesn't mean there was a duty to do that. For example, I'll give you the example of a rolling desk chair. Arguably, it would be safer if it didn't roll or if it was permanently affixed, but it doesn't mean that it's not safe, the fact that it can roll. So this bunk bed ladder was designed to be removed.
But if that rolling desk chair only had, 3 legs, maybe that would be a problem, right?
Perhaps that would be a problem, but there's no evidence in the record that the bend pre-existed the injury. The fact is that the plaintiff's daughter used that very same ladder for months, including the morning of the accident, with no issue. And the plaintiff herself testified that the ladder, there didn't seem to appear to be anything wrong with the ladder as she ascended it. She actually got up 3 or 4 rungs and it felt secure. There was nothing wrong with the ladder up until the moment that she fell off of it.
Any further questions? All right, we will hear from you on rebuttal, okay? Thank you very much.
Thank you.
Mr. Hayworth, you want to go next since you're also a defendant, a third-party defendant, I think.
Thank you very much, Your Honor.
Thank you.
Unless Your Honors have any questions, I'm going to rest on the papers. I don't think I have anything to add.
Anyone questions specifically for Mr. Hayworth? All right, well, I'm glad I gave you the time.
Thank you very
No, I'm
much for
only
the
kidding.
opportunity, Your Honor.
I appreciate that. If we don't have questions, because obviously we do. If we do, we'll certainly ask them. Plaintiff's counsel, Mr. Isaac, I believe you're speaking for the plaintiff here.
I am, Your Honor, and good afternoon again. I represent the plaintiff respondent here. First of all, there was evidence from Mr. Folio, from the defense expert, and from Mr. Ehrlich that this type of damage to the bent hook would not have occurred spontaneously and would not have even occurred from usage, especially with respect to a 160-pound individual. Judge Kapnick, as you pointed out, the plaintiff did testify that she would hear a clanking sound every time she used the
plaintiff's daughter, I guess.
Yes, plaintiff's daughter, and that the base of the ladder, the feet, were not flush with the ground. And although Mr. Folio did state that the ladder had structural integrity despite the feet, he also said on 343, 356 to 357 that when the feet were on the ground, it would enhance stability. Mr. Ehrlich's testimony was to the effect that 4.4 pounds of force could cause the hook to disengage and move to the right, which is exactly what happened. But the pièce de résistance, and I'll be clear as well, is this is a summary judgment motion. This is Ms. Yamrick. This is the dean of Marymount, not my client, not an expert. 267, here's what she said. Question, if the feet of the ladder were not flush to the ground, flat on the ground, would that be a problem? Answer, yes. Question, would that be considered something that would have to be repaired or fixed? Answer, yes. Question, would it be considered dangerous if the feet of the ladder were not flush and fully flat on the floor? Answer, yes. And then she carries over to 270 on page 222. Question, all right, if an RD or an RA during an inspection or walkthrough saw that one of those hooks of a ladder looked like that, bent like that, would that be considered a problem? Answer, yes. Would that be considered a reason to either repair or replace the ladder? Answer, yes. That's the defendant's deed. So I may not win. It may not be a 240 case. It may not be a hit in the rear case, but it's certainly not a summary judgment case. And the last thing I would add, if you have no questions, is that the college's reliance on their reports on the inspections was completely impugned by Paige Hawley's testimony that she didn't inspect specifically for the ladder, that she only checked for what she said was, quote, something, quote, obviously wrong with the furniture, and that her inspection didn't include verifying that the ladder's feet were flush with the ground. And that's on page 490 to 491. If you have nothing else, I'll rest on my brief. Thank you for listening to me.
Thank you. Okay, Ms. Riccardouli, you have 2 minutes for any rebuttal. Thank you.
Yes, I'd like to address the two pieces that Mr. Isaac brought up regarding Dean Yarmick's testimony. The first piece is the hypothetical that was posed regarding whether the feet should be flush. Ms. Yarmick is the dean of the school, and she's not an expert who's qualified to opine on the structural integrity of the design of the.
But isn't that something common sense tells you that things should be flushed to the ground? I
agree, but the testimony of the designer of the furniture was that the feet did not need to be flushed to the ground in order to be secure, because that wasn't the main means of securing that ladder to the bed. The second piece.
So, counsel, let me just say, are you saying that we should disregard the testimony of your witness?
I'm saying she was given a hypothetical and she answered it, but she's not.
Okay, but that was her testimony, right?
Yes, but she's
are
not.
You saying we should
not
disregard it?
And there's no evidence in the record that there was some visible problem with the ladder such that you could see it was not flush.
Well, didn't the plaintiff's daughter say it wasn't flush?
She said that when she heard a sound when she climbed on it, but
that the foot and the feet weren't flush, right?
But that's not necessarily.
And then you have your president saying, yeah, that's a problem if the feet aren't flush. And you're saying we should just ignore all that testimony and based on your expert affidavit, issue a summary judgment decision?
No, what I'm saying is that those things can exist together. It could be that she stepped on the ladder and it made a clinking sound, but also to the visible eye, it did not appear not to be flush. But
don't those things at least create an issue of fact? What we're dealing with here is just summary judgment.
Well,
and
no,
a denial of summary judgment based on there being issues of fact. It seems to me that everything you've just discussed with Justice Scarpula are about issues of fact.
Well, but the fact remains is that the fact that the feet do not need to be flushed in order to be secure the question of fact is immaterial to our negligence, because the fact remains is that the ladder was secure when the hooks were hooked to the side of the bed. Whether or not the feet were flush are immaterial to our negligence regarding the proximate cause of plaintiff's fall. The second issue regarding her testimony is of if she saw the bent condition of the hook, if that would be a problem. The record is clear that bent condition didn't exist prior to the time of the accident.
How do we know that? I understand you keep saying that. I think I'm missing something.
Well, the testimony is that during the months and months that plaintiff's daughter used that ladder every day to get on and off the bed, she never noticed anything wrong with it. The inspections that were done never uncovered
But there's no evidence. I'm sorry, excuse me. It seems to me that there's no evidence that the inspections your client did involved looking at the ladder. So I don't see how we can give any weight to the reports of those inspections.
There is. The furniture was inspected and there were room condition reports done before the start of every semester, and there was line items for the bed, which necessarily involves the ladder that was attached.
But there wasn't specifically a line item for the ladder. There was one for the bed, but it didn't specifically indicate the ladder, did it?
No, but there was a line item for the desk and not a line item for the drawer either. It's part and integral to the lofted bed.
Was there counsel, this is just our pool. Was there testimony from the person who did the inspection? Yes, I inspected those hooks.
No, there was there was testimony that the furniture was inspected.
Right,
which
but
doesn't
that
show-
means you know who inspected, right? You could have gotten an affidavit from that person that said, sure, I looked at the hooks, but that, I didn't see that in the record.
Well, the plaintiff herself signed off on the plaintiff's daughter herself signed off on the room condition report, which necessarily included the bed. And she
Well, if
didn't
I asked my
find-
19-year-old daughter whether or not she looked at the hooks that were connecting the bed to the loft, I'm pretty sure that would be the last thing she would certify one way or another.
Well, don't climb up the ladder next time you go visit her, Justice Ortula.
There's testimony in the record that the ladders were checked to ensure that they were secured to the bed.
Okay.
I believe that if there was
I think we're kind of going over the things again, and we still have several more cases. I thank all three of you very much for the arguments, and have a very lovely rest of the day.
Thank you, Ronnie.
Okay, the next case for argument is Word of God versus Vimeo.
Wait, what about Nunez?
No, I'm sorry, People versus Nunez. I apologize. People versus Nunez. Okay, sorry about that. Appellant, you have 5 minutes. Go right ahead.
Good afternoon, Your Honors. My name is John Palmer, appearing on behalf of Miguel Nunez. At the time of the instant offense, Miguel Nunez was an 18-year-old boy caught up in a pattern of misbehavior and offending that stemmed from feelings of isolation and otherness he experienced since he moved to this country at 12 years old. But he emerged from prison at 28, level-headed and motivated to play a supportive role in his young son's life. Based on these circumstances and others, we ask this court to afford Mr. Nunez youthful offender treatment or reduce his sentence in the interest of justice. The factors justifying youthful offender treatment weigh in favor of adjudicating Mr. Nunez a youthful offender or reducing his sentence here. There are mitigating circumstances present in Mr. Nunez's background that contextualize his offending and demonstrate that he was no hardened criminal.
Well, Mr. Palmer, I have to say that we previously sent this back specifically for a YO determination. I was on that prior bench also, and the Judge Alvarado, seemed to have had a very lengthy hearing where he heard all of this testimony, some of which you're summarizing here on your argument, and decided after all of that testimony, and also the fact that there were some violent felonies he committed while was waiting for sentencing at that time, that he was not going to do that, that he was not going to grant him YO determination under all the factors. Why should we review, de novo what Judge Alvarado did so seemed like painstakingly in a very lengthy hearing?
Correct, Your Honor. He did issue a very lengthy findings of fact and decision here. But, Your Honors, the standard review here is not for an abuse of discretion. This court has independent interest of justice authority to grant Mr. Nunez youthful offender treatment.
No, I understand, but we certainly do look at what the trial judge or the hearing judge, heard before him below and give some credence to that. I understand that. Yeah.
Right. And Mr. Nunez did reoffend throughout the court between, his arrest and sentencing in this case. But, Your Honor, who we are at 18 or 19 and 20 in Mr. Nunez's case is not who you are for the rest of your life. And at resentencing, Mr. Nunez demonstrated a more positive attitude towards society and respect for the law, as well as prospects for rehabilitation and hope for a constructive life.
Counsel, this is Judge Owing. On all those reoffenses, was there a weapon involved?
Mr. Nunez pleaded guilty to trying to forcibly remove a chain and money. In two of the cases.
No, I asked you a simple question. Was there a weapon involved in all those offenses?
Not in all of those offenses. He pleaded guilty to attempting to possess a gun in one of the offenses. And when he left prison, he was motivated to support his son and remove himself from the trouble that he found here in New York. And he found his family's support in those efforts. And further, between his release from prison and resentencing, he engaged in a job readiness program and therapy, which he started, that was beyond what his parole required at that time.
But am I wrong, or is the defendant currently incarcerated pending trial on an unrelated matter?
Yes, he is currently incarcerated pending trial on an
So how does that
unrelated matter.
go along with your presentation to us about how he came out, he's a different man, and he's sort of taken his life in a different direction because of his son and his connections?
Your Honor, the simple fact of an arrest does not mean that he has not taken steps to improve his life. In that case, he has not been found guilty or pleaded guilty to anything. That case is open and is not.
So, Counsel, it's your position that that has no, that should have no bearing on our determination.
Well, Your Honor, that is information that is outside of the record and actually came after the resentencing court made its determination here. So it should not have any bearing.
But at the time, but at the time the sentencing court made its determination, there were a number of, as Judge Owing was trying to bring out, there were a number of incidents that your client was involved with, and unfortunately involved with a gun, right?
But one of those incidents involved a gun.
Well, in this instance, wasn't there a gun involved?
Actually, Your Honor, Mr. Nunez was acquitted of robbery in the first degree, which shows that the jury did not credit.
Was there a gun in his hands?
That was the testimony, but the jury did not convict Mr. Nunez of robbery in the first degree.
You convicted him of second-degree robbery, right?
Second-degree robbery aided by another. Yes, Your Honor.
Okay, let's hear from the DA, and you'll have a minute or so for rebuttal. Thank you, Mr. Palmer. Counsel for the people?
Yes, may it please the court. I'm Morgan Namian for the people. Your Honor, I think.
So can you clarify for me, Counsel? This is Judge Owing. Was there or was there not a gun involved in the prior offenses?
I mean, yes, the testimony was that there was a gun. If you look at the victim impact statements, you can tell that this wasn't a situation where just a guy like scared these kids on the street. There was something. One of the brothers testified that he looked back and the guy told him to keep running.
And with respect to the prior offenses, there was no, Counsel saying there was no weapon involved because there was, I guess, am I reading the record wrong?
For the prior, so his prior youthful offender, and no, my understanding is that there were no weapons involved. However, the first one, yeah, that's my understanding.
Okay. Thank you.
But Your Honor, so I think my argument's pretty clear on the excessive sentence and the YO adjudication. I think my brief is pretty clear that, look, the sentencing court here did a pretty painstaking job of going over, okay, had I considered youthful offender treatment at the original sentencing, this is how I would have come out. He would have imposed the same sentence, would not have found that YO treatment was appropriate. And then reassessing all of those factors in addition to what was posed in, or what was contained in the resentencing memorandum, and significantly considering the fact that these three, felony convictions that were pending had actually ripened into convictions. Even with all of that information, this court still denied YO treatment and imposed the same sentence. There was some concern, it seemed, that whether this court could resentence based, concurrently versus consecutively with respect to the subsequent sentence. But once I think, counsel on both sides solved that issue at the resentencing phase, and the court, because its analysis of the various factors at both times changed nothing for the court. It was within its discretion to reimpose that same sentence and deny YO treatment. Moving on to the waiver of the fees issue, I just want to point out that in defendant's reply brief, though he does, provide more law for why this court can waive and remit these fees. It's our position that he paid these fees in full, in March 2015. Nothing in the brief indicates that this was ever a hardship. So even though the people's initial position is that this amendment is not, retroactive. Yes, we do, want to go through that and say, he didn't even try to make some showing of proof as to hardship. So for that reason, we are opposing the waiver and remitter, and would hope that this court does the same.
Anybody have any further questions? Okay, thank you very much, Ms.
Thank you.
Namian. Mr. Palmer, you have a minute for rebuttal.
Yes, Your Honor. First, as to the waiver and remittal of the fees, complying with the court's order to pay those fees does not mean that Mr. Nunez did not find it burdensome at that time, or that returning the money would not promote his reintegration to society or alleviate financial stress on him and his family now. Mr.
But
Nunez.
do you have any evidence that it was burdensome?
Or did you put in any evidence?
Well, he was indigent at the time of the offense. He was indigent when he paid when he was incarcerated, indigent, and had a young son at the time the fee was imposed, and at the time that he paid the fees, and he remains indigent now.
What's the evidence establishing that?
That this court assigned counsel to this appeal, the previous appeal, and the Supreme Court provided counsel at the time of trial and in the plea cases that followed, Your Honor. And this court has waived or remitted surcharges and fees in interest of justice on several occasions.
Mostly we have done that in cases where the district attorney has agreed with it, and even though we haven't found it retroactive, at least in the first department, as you well know, we have done it on consent, but that's usually how we've done it. Does anybody have any further questions for Mr. Palmer? Okay, Mr. Palmer, thank you very much for the argument. Thank you, Ms. Namian, and have a good rest of the afternoon.
Thank you.
Thank you.
Okay. Now we have word of God. Sorry for calling you prematurely. Do we have the appellant here?
You do, Your Honor. Good afternoon. May it please the court. I am Alfred Marks from Dade Pitney, co-counsel with Michael Anderson from Kelly, Hart, and Holman in Fort Worth, Texas, for Plaintiff Appellant, Word of God Fellowship, Inc., doing business as Daystar Television Network. It's my pleasure to introduce Mr. Anderson, a member of the Bar of the State of Texas, who has been admitted pro hoc vice by this court in connection with this appeal. With the court's permission, Mr. Anderson will proceed with argument on behalf of Plaintiff Appellant.
Yes, that'll be fine. Thank you, Mr. Marks. Good afternoon, Mr. Anderson. You have 6 minutes and you're welcome to proceed. Welcome.
Thank you, Your Honor. May it please the court. Good afternoon. The position of Daystar in this appeal is that the trial court erred by dismissing Daystar's complaint for breach of contract and unjust enrichment at the motion to dismiss stage. Daystar pled that it had a contract with
Counsel,
the
this
three.
is Judge Singh. Counselor, there's a statute at issue here. Okay, the CDA. How does that impact on your breach of contract claim as well as your quasi-contract claims?
Thank you, Your Honor. The CDA, the federal statute, it is an affirmative defense, and in particular, the courts have recognized it as an affirmative defense. The Second Circuit in the Ritchie case, that is 781 F 3rd 25, the pinpoint side at 28, Second Circuit 2015, and other courts have held that the CDA is an affirmative defense, and that as such, that the only way to raise that at the motion to dismiss stage is if the defense is evident from the face of the pleadings.
So, counsel, this is Judge Scarpula. What's the breach that you allege? What part of the contract are you alleging was breached?
Yes, Your Honor. The order form constitutes the contract where
I know it. Just tell me straight up. What section are you saying was breached?
Removal of the 5 videos without our permission.
Breached what? What section did it breach? They have the right under the contract to take out what they, in their opinion, deem objectionable That's it. So I'm saying, what was breached? They did that. They did what they're entitled to do under the contract. So I'm still trying to figure out what section of the contract are you saying they breached?
Your Honor, there's two parts there. Number one, there is nothing in the record as far as that they have the right to remove content. They, as they admit on page 28 of their response brief, they did not attach the applicable terms of service for the OTT over the top.
So let's get past that technical. I really want to try and figure out, what are you saying is the breach? Assuming that we get past your argument that all those other things aren't included in the order form. Let's assume that they are. What's the breach?
Yes, it is the breach under the products and services purchased on the order form. That's at the record of 55, where we have paid $576,000 for Vimeo to host our content so that viewers can go to the Daystar website and view content.
So, counsel, let me interrupt you. And do you disagree that they have the right to pull content under the contract? They have the right to pull and take down videos that they find objectionable. Do you agree that that they have the right to do that?
I do not agree with that, Your Honor, and let me tell you why. Isn't
that what the contract says? In particular, could you address page 63 of the record where it says that they have the right to take down content?
63 of the record.
Vimeo may take all appropriate actions to enforce its rights, including removing specific videos.
You are on the terms of service for an enterprise user, which we are not an enterprise user. An enterprise user is anybody in the public that would pay a nominal fee to have their content hosted. Daystar, on the other hand, is an OTT subscriber. Different rules apply to it. Okay, so that's the answer to that. So different rules apply, and they have not, as they admit on page 28, they did not put in the quote applicable terms of service. So that's outside the record. Number two, they have to, it says, even for the sake of your question, your argument, it's false and misleading. It says it has to be false and misleading. At this stage of the case, at the motion to dismiss stage, the allegation has been made that in these 5 videos do not contain false and misleading statements.
So, counsel, is it your position that we have to have a trial on every video that one person finds objectionable, that the Vimeo finds objectionable, to see if it falls within that subsection of the contract?
Absolutely, Your Honor. That would be the whole purpose. Do you think that you can just allege
that I don't think this is false and therefore you can't remove it? And that would be a good breach of contract claim?
Absolutely, Your Honor. And hear me out on that. My client paid $576,000 in order to have content posted and available.
Wait a second, let me just ask you this, because I find if I post a video that says the Holocaust did not occur, and Vimeo wants to take that down as false and misleading, you're saying that I can allege in my complaint that that is not false and misleading, and that we'd have to have a trial on that? All you have to do in your complaint is allege it, and then we have to have a trial on whether or not the Holocaust occurred is false and misleading?
Your Honor, that's an entirely different.
Why is it different? I mean, you're saying all I have to say is this isn't false and misleading, and I plead a breach, right?
Well, what I'm saying is when we have pled that it does not contain false or untruthful, false or misleading statements.
Isn't that just what you're saying, right? And that in that case, we have to have a trial.
Our scenario, with all due respect, does not involve the Holocaust. It involves
I understand, but it's
investigators in
the
a
principle.
documentary.
The principle that you are saying is anytime I make that allegation in my complaint, it has to go forward, correct? Regardless of whether or not it is something that from the face of the record we can see.
I think as a general proposition, that would be correct, Your Honor. Where if we have a contract and we have paid substantial amounts of money under that contract to vest with one party to make their own decision, again, these are on terms not in the record, but to vest with one party the unilateral decision making, and they have zero consequence for it. And all they have to say.
Counselor, I'm sorry. This is Judge Singh, and I want to sort of go in a slightly different track. I want to assume that you have a breach of contract claim, but doesn't the CDA provide immunity even at this pleading stage?
No, it does not, Your Honor. And
are you suggesting that courts have not held that it does provide immunity?
No, I'm definitely not suggesting that. There are different scenarios where you could have immunity, and there's scenarios where you don't have.
So in this context, it's the position of the defendant essentially that the videos are otherwise objectionable. They remove them. Why can't they use the CDA as a shield at this juncture to say that it's done in accordance with federal law?
And let me just add, and because it is done in good faith.
All right, two issues there. Number one, we dispute that it was anything was performed in good faith. So what Your Honors have alluded to as far as the good faith and whether it's otherwise objectionable is section 230 C2A. All right, under 47 USC section 230 C2A. Now, first of all, it has to be evident from the face of the complaint. I disagree that it's evident.
So, okay, so in this case, in this case, there are videos concerning vaccines and the efficacy of vaccines. Now we're living in a pandemic. How can you argue under these circumstances that those videos, which take a view, and everybody's entitled to their view, can't be taken down because the defendant finds them to be otherwise objectionable?
Well, that's a very good question, Your Honor. And the reason being is, A, there has to be good faith. Vimeo has already said they have no power under the CDA to remove truthful vaccine content. They've said that in their brief at page 16. They have no power to do that. There is no evidence that these 5 videos contain untruthful information to the nothing in the record, no evidence in the record.
But it's not truth or falsity, right? It's what's objectionable and is the act done in good faith? That's what we're dealing with, because we'll debate forever whether it's true or false, and people will be on either side of that position. Question is it otherwise objectionable to the provider?
All right, 2 issues there. Number one, you have to get past the good faith part, and I submit that is an absolute question of fact. That is a trier of fact.
So, counsel, this is Judge Scarpula. What facts have you pled in support of bad faith?
Absolutely, Your Honor. We have pled, I'm going to start with this. Prior to Daystar being solicited by the Vimeo defendants to move, Daystar was on the Bright Cove platform. Many of these vaccine videos Daystar was already using and was already broadcasting.
So you're saying they lured you into their website with the intent that ultimately they were going to take these videos off because they knew that you would continue on with those websites, but they knew that before they solicited your business. Is that what you're saying?
Yes, there's a flavor of that, meaning that we had that was our pre-existing content, Your Honor. They then solicit us, and it's not just a solicitation of, hey, here's a phone call. This is, again, a $500,000 deal where executives from Vimeo came down to the Dallas-Fort Worth area, solicited our business, said that they liked our content. When our content had this vaccine information about the efficacy of it already in it, they liked our content and that our content was a good fit. All right, so we have that. They never once voiced a single objection to any of our content. And of course, that goes into the allegation.
And when was that time, counsel? When were the solicitations?
The solicitation was during the summer of 2019.
And when did the pandemic, I mean, can we take judicial notice of the pandemic? When did the pandemic and all the issues that have arisen as a result of it occur?
I believe, people say February or March 2020. Okay. But that wasn't.
So how can we look to what occurred prior to the pandemic to say that they're acting now in bad faith because they solicited business knowing that there was vaccine content already there?
Well, here's how we can look to it. We take their own word. They claim that vaccine information as early as August 2019. This is in the record. They claim in August of 2019. They were already concerned about vaccine content. Well, that corresponds with the time when they are soliciting my client's business. And so they are soliciting. It wasn't the pandemic that turned anything around for Vimeo. It was rather, if you take their word, they were already concerned about it in May of 2019. And so, but when we get into this back and forth about the timing of that and whether it goes to good faith, bad faith, that highlights and underscores the issue.
So counsel, let me ask you one thing. Are you saying that there's in the record a conversation that they had with you about those videos where they said, yeah, we like those particular videos. We want the sort of, for lack of a better word, anti-vaccine videos on our website and then later change their mind? Is that what you're alleging? You were just saying they came down, they want your business and they get your business and then afterwards they go through and they decide these videos are objectionable to them. And that's your allegation of bad faith?
Several issues there, Your Honor. Number one, I'm not saying that that when they came down here, that they specifically called out these 5 videos. I am not saying that. What I am saying, however, is that those, not all of them, but some of those videos were already being broadcast and the allegation, the representation was being made that it's at record 46, it's paragraph 19 of our complaint, that they said that our content was a good fit.
Counsel, where does that appear in the record? I in opposition to the motion, all I see is a memorandum of law. There's no affidavit by a principal of Word of God Fellowship saying that we were solicited, they loved us, they liked everything about us. There's nothing like that in the record, is there? I'm looking at the record as we speak. I don't see anything like that.
We have our complaint. There was no requirement that our complaint be verified or sworn to.
I understand there's no requirement that your complaint be verified, but in the absence of a verified complaint, what evidence is there? What sworn testimony is there that you were solicited in that way?
Well, the evidence is the pleadings at the motion to dismiss stage. The pleading, which is at record 46, it's paragraph 19 of Daystar's complaint, is that Vimeo, quote, represented to Daystar that its content was a good fit on the Vimeo platform. And then, Your Honor, to further, when you ask—
But that's not a verified complaint, right?
That's right. It is not. And it's not required to be, Your Honor.
No, but it's not specifically about these videos. It's just, we want your business and we like your content, right? You're not making a specific allegation about, we think these videos are good.
No, the allegation that is being made is some of the ones they removed were being broadcast. This wasn't an issue where everything they removed was added after.
We understand, guys. We've given him like 17 minutes to talk, and I want to try to get through the calendar. So could we hear from the other side, and then we'll give Mr. Anderson a couple minutes to rebut. Okay, Mr. Anderson, thank you very much. I appreciate it. Do we have respondent here?
Yes,
Mr.
Your Honors.
Chia?
Thank you, Your Honors. Good afternoon. Michael Chia for Vimeo. May it please the court.
So, counsel, may I ask you to address first off the allegation that the correct contract and the contract that you are trying to enforce is not in the record?
The contract is in parts in the record. The contract consists of an order form which buys the service, and then a number of linked documents which are online. And the principal one that's linked from the order form is called the enterprise terms. That's in the record, and it specifically says we have the right to remove content. And then it incorporates a number of other links that relate to specific services. We did not include the correct form for the OTT service. However, we did provide all of the other ones that have the same content restrictions. The content restriction about vaccines goes throughout our platform. We operate a global platform. It makes no sense for us to have different terms of service. That was an error, but there's never been any dispute that we have had that in our contracts. And the complaint pleaded into this by the mere fact of saying our content was not false and misleading. They acknowledged essentially that this was the operative contract. And in the opposition, they went with it. They acknowledged the contract. It was only an oral argument where I discovered for the first time that we didn't put it in. Had I had the knowledge, we would have absolutely done so. I would have done it as a reply affidavit had it come up in the opposition. I consider this argument waived, but it's also, as I think Judge Scarpullo said earlier, it's a technicality. The contract clearly gave us the right to remove objectionable.
Okay, so how do you get over the allegations of bad faith that you took this down, that you have the right to take down objectionable content, but you acted in bad faith in that allegation?
Yes, thank you, Your Honor. Good faith is a component of the Section 230C2A defense, and it is evident from the record. Why? We had a pre-existing policy against false and misleading vaccination materials. We gave the plaintiff very specific notice, a detailed letter that said, here are the videos, here are the timestamps in the videos that say that vaccines cause autism. And we gave the background as to why we thought that was false and misleading. We highlighted the CDC, the NIH, other sources. We gave them an entire month to respond. They did not respond, nothing, absolute silence. So finally, we said, we're in the middle of the pandemic. We're taking these videos down unilaterally. Didn't want to do that for a large client like this, but we had to do it. We felt we had to. That evidences good faith as to the decision. And all I've heard in both the complaint and the record is something about.
Counsel, this is Judge Owen. I got to ask a question. Plaintiff, where they're coming from. I mean, they in terms of their anti-vax position, right? Before you entered into a contract with them, you knew with their platform. No?
Disagree, Your Honor. We thought that they were a Christian evangelical network. They are. They're the second largest. Right. I believe the second, maybe even the first, the second largest Christian evangelical network in the world. We want to be a home for religions of all kinds. We thought they would be a good fit because we looked at them and we saw Christian content.
So these anti-vax videos came after the contract was executed?
No, they were probably up as plaintiff says on their own platform, but you got to understand, these are 5 videos out of 3,000, more than 3,000 discrete pieces of content that were uploaded. These are long form things. These are an hour to 2 hours each. These are people having talk shows. It is sermons. It is a lot of content. The idea that a salesperson at Vimeo went through and watched 3,000 hours of Christian content to make sure
about binge watching. Binge watching.
Yes, Your Honor. We would do very little sales if we actually did that for all of our clients. The flip side here is they had the ability to see what our terms were. We don't hide our terms. I did a blog post about the vaccination policy. They're online. counsel keeps on saying this is a $600,000 contract. Well, did their lawyers look at the contract? Did they point out to them, hey, you know what? These guys don't seem to like vaccine misinformation.
Maybe you answered this question, but how did you get alerted to the fact that you had these videos out there on the anti-vax stuff?
Your Honor, I don't recall the specific how, but in the course of the pandemic, this took on a new salience. Either they were reported by a customer or another user, or one of our employees found them. That is the typical way.
Counselor,
it is not our
Judge Singh, Counselor, are there any facts alleged in the complaint that from which we could infer at this point that in fact there was bad faith?
Absolutely not. The allegations about we lured them into this, as I've already said, they're conclusory, they're in the wrong time period. There's nothing that says your decision to remove them was pretextual. There's nothing that says you're insincere about your vaccine policy. That would be bad faith, right? If we said one thing and we really meant another. We had every financial reason to keep them as a client. In fact, by taking this down, we ended up losing them as a client. And so we acted against our own financial interest here because we thought the principle of taking these things down was more important than the money. And that's what needs to be
Did you refund their money?
Oh, we did not, Your Honor. We provided 2 years of video hosting of thousands of videos.
Right.
Taking down 5 videos doesn't even breach the contract, even if
I was just curious.
So the primary argument, it seems to me, or maybe the strongest argument, is that these issues of good faith, bad faith really should survive a pleadings motion, discovery, summary judgment. I mean, which is in general how we handle these things. Why in this case should we not follow that procedure?
Well, first of all, just to point out, this is a CPLR A32A7, sorry, A1 and A7, so it's undocumented evidence, not just the pleadings. This court's jurisprudence does not accept conclusory statements like we breached the contract or you committed negligence. You have to do something more than that. But more importantly than that, for the purpose of the Section 230 immunity, it's vitally important that we don't have to have a trial every single time we take down content. And let me just read to you the express preemption clause in the statute. It's in 230E3, and referring to the second sentence, it says, no cause of action may be brought and no liability may be imposed under any state or local law that is inconsistent with that section. Now, I don't know how you prevent people from bringing a cause of action, but the next best thing is to dismiss it early, at an early stage. And that's what the case law says. It says these cases should be dismissed at the earliest possible stage, and conclusory allegations about bad faith, fraud, whatever, they should be disregarded, because if that's enough to defeat a motion to dismiss, then you force every service provider to summary judgment, to a trial. You rack up expenses. You make it very difficult for them to voluntarily take down bad content. And that's what Congress wanted. They wanted service providers like us to take down content. Most of the time you're hearing about service providers not doing enough. This is a service provider that did do something, took down bad content. That should not be punished.
Mr. Chia, I have a question. In response to Justice Singh's question, you said that you did not refund them their money, but in your letter, you said that you would let them terminate their contract after 1 year if they asked you to do that. Did they ask you to do that?
They did not. They actually bought another order form. They increased the amount of content that they wanted to stream, and so
after receiving the letter from you.
That's correct. So actually, we somehow got more money from them after that fact. And then when the 2 years finally expired, they did go with another provider, because by that time they had doubled down on coronavirus misinformation to such an extent that it was completely incompatible with being on Vimeo.
Okay, any further questions for Mr. Chia? Okay, thank you very much, Mr. Chia. Mr. Anderson, you have 2 minutes to respond.
Thank you, Your Honor. I want to address a couple of things. Sure. We just heard that they sent a letter and Daystar, my client, did absolutely nothing. That's not true. There was actually a follow-up telephone call in which these issues were raised.
I'm sorry, I think you're referring to my question. I didn't say you did nothing. I said you didn't terminate your contract after 1 year.
Your Honor, I wasn't referring to your question. I was referring to counsel's statement earlier where he said they sent a letter and what happened after that? Nothing. We heard nothing from them. That's not true. We actually did have a sit-down Zoom call with Vimeo. This notion too that, hey, Daystar continued for another year. I don't want this court to be misled. It's not as simple to simply turn it off and go to another provider. Daystar, the reason when it entered into the contract with Vimeo, it doesn't go live the very next day. It takes time to set up the apparatus to do that. And Daystar has done that now. That's why it's no longer with Vimeo. But back to what I heard, what Justice Singh's point is this. There's a lot of good faith, bad faith. Recall that the CDA section 230 C2A, it has to be evident from the pleading, the affirmative defense. We're at the pleading stage. We're literally at the pleading stage. It is not evident from the pleading that they had good faith. All right, so that's just simply not correct.
Well, are you suggesting, Counselor, are you suggesting that this policy did not wasn't already in existence? Is this a policy that they concocted after the contract was entered into?
No, what I'm saying is that it goes back to, was it false or misleading? Did they have a good faith belief that it was false or misleading content? And from that standpoint, that is an issue of fact that needs to be tried, because what we have here, even though they say, hey, they've moved under this under a documentary basis, there is no evidence in the record to support, hey, this is our good faith belief that this is false and misleading.
But don't you, I'm sorry to interrupt, but don't you have to plead facts, as Judge Scarpullo was suggesting in her earlier questioning, from which we can infer bad faith?
No, we don't have to plead that, but we have done it, Your Honor, and we've done it.
So where have you done it? Tell me where you did it.
We've done it at the record. I'll give you the paragraphs at record 46. These are all collective. If we take paragraphs 19 and then R48, paragraph 25, at R49, paragraph 27, at record 50, paragraph 29, where we have made substantive allegations that would defeat the notion that they did this in good faith, not simply a bare bones pleading that says they did not act in good faith. Now, there are a litany of factual allegations that I just pointed to, in which it would certainly be, I believe, it would show it doesn't support a good faith finding, and at a minimum, it would be an issue of fact. And that's where we are, is at the pleading stage. That is an issue of fact.
But as your adversary points out, the statute, the protection the statute gives is frankly quite broad. It says, quote, no cause of action may be brought and no liability may be imposed under any state, local law. That's inconsistent with this section. So how does that interplay with even frankly our pleading standards here?
Well, where it interplays, Your Honor, is that means it's still an affirmative defense. Just because you have that section, you still have, they would still have to satisfy evidentiary wise C2A. They would have to.
Counsel, this is Judge Scarpullo. I mean, I read 20 cases that go the exact opposite way, that say they don't have to satisfy, that the court can, on a pre-answer motion to dismiss, look at this issue. How do you distinguish all of those cases? The Ninth Circuit, the Second Circuit. I mean, how do you distinguish all of them?
Well, thank you, Your Honor. We have a number of cases going our way. How I distinguish them is that in the cases, to the extent they went 230 C2A, good faith was evident from the face of the plaintiff's complaint. That is not the case here. And when we talk about the Ninth Circuit, recall under 230 C2A in the Enigma case, where they tried to use the catch-all and say they had good faith. We have this catch-all. The Ninth Circuit said, no, we're not going to read 230 C2A that broadly. And that's where it all matters on the particular facts at issue.
Okay,
And
well, Miss, I'm going to have to finish the argument. I think we've kind of gotten all through our questions. We otherwise have your record and have the briefs, and we're certainly going to take a careful look at this. We thank you both very much for your appearances today, and Mr. Marks too, and have a great afternoon. Thank you all very much. The next case for oral argument is Max versus ALP. The appellant, you have 6 minutes. You may begin.
Thank you, Your Honor. Karen Klein, on behalf of appellant, who brought this action derivatively and directly on behalf of ALP. Appellant pled in his complaint, among other things, that defendants as officers and directors of ALP misappropriated money from the company as expenses that were not actually incurred, misappropriated artwork from the company without compensation, provided the New York Times with false information to make it appear that ALP's customers were purchasing counterfeit goods, fired essential employees and failed to appoint replacements, such that the company was no longer able to function, impeded the collection of over $200 million in insurance and other claims on behalf of the company, and caused the company to abandon its essential business lines and destroy its business relationships, such that the company no longer had a single viable customer. The trial court erroneously held that this failed to state a claim. In doing so, the court failed to draw all inferences in appellant's favor on respondent's pleading motion, as it was required to do. Appellant's complaint sufficiently stated claims against respondents for breach of fiduciary duty, negligence, accounting, attorney's fees, removal of officers and directors, and appointment of a receiver. Now, the trial court erred particularly in holding that all of appellant's claims were barred by the exculpation clause contained in ALP's certificate of incorporation. It is undisputed that that clause does not apply to actions that are taken in bad faith, actions that involve intentional misconduct, or where directors personally gained a financial profit or other advantage to which they were not entitled. Appellant's allegations that respondents stole money and artwork from the corporation meets all three of those exemptions. In addition, appellant pled a pattern of respondents' misconduct, which he alleged was undertaken in bad faith and out of a personal vendetta, and that conduct functioned to destroy ALP, leaving it without any customers and without any funds. This is sufficient to plead an exception to the exculpation clause. In addition, that clause only applies to claims for damages as a result of actions taken in the capacity of directors. Appellant's claims do not only seek damages, and they also assert claims for Libra in her capacity as an officer of ALP. Even if the exculpation claim, the clause barred any claims, it did not bar those claims.
Counsel, this is Judge Singh. How does the business judgment rule apply to your claims, specifically really relating to the breach of fiduciary duty?
Thank you, Your Honor. The business judgment rule, the law is clear that pre-discovery dismissal in the names of the business judgment rule is not appropriate where, as here, the pleadings suggest that directors did not act in good faith. This is not, as the respondents claim, merely a disagreement about business strategies, nor is it, as the trial court held, appellant bringing this claim because ALP was being operated in a less profitable manner. Rather,
what are the claims that you make for bad faith? Seems like that's the theory this afternoon, or but what are the bad faith claims that you are making towards Libra and Anderson in this case?
Thank you, Your Honor. So we allege that Libra and Anderson both misappropriated money from ALP under the guise of expenses that were not actually incurred. We allege that Libra misappropriated artwork from ALP and without consideration.
Counsel, this is Judge Scarpullo. What does that mean? What artwork are you talking about? I mean, did you list what kind of, you have to be pretty specific in a claim like this. Can't just say bad faith, breach of fiduciary duty. I know this, you know this. What paintings are you saying they stole?
Thank you, Your Honor. I appreciate that. We have pled that Libra took paintings and undertook a pattern of taking paintings from ALP. It was not merely one painting that we've alleged she took.
What does that mean?
Provide
so
compensation
what
for.
paintings did she hang them in her apartment or what?
We have pled, Your Honor, that she took these paintings, and we've also alleged that we have sought additional information that we're entitled to from the company.
Let's start again. It's not enough to say she took paintings in general, right? That's not going to cut it. On information and belief, she took a bunch of paintings. What specifically are you saying that she took that would lead to us to even look beyond the broad exculpation clause? You have a broad exculpation clause. You can't get away from it by just saying she did bad stuff. You have to be specific. What specifically are you saying?
Thank you, Your Honor.
You're welcome.
With respect to the theft of paintings, Your Honor, there are things I could say that are not in this record, so I'm trying to stay within the record.
Right. So I want you to tell me what is in the record.
Well, Your Honor, the record makes clear that we said that she took the paintings. It does not specify the particular paintings. It does not specify the particular dates she took the paintings. We did ask.
I mean, it just says as a general matter, she took stuff, and that's going to get you past the exculpation clause?
We pled that she engaged in a pattern of taking these items.
Again, that allegation is going to get you past the exculpation clause without any specific facts backing it up?
I mean, there are.
Sorry, go ahead, Your Honor.
Apparently, many paintings in the wherever they kept them in the various places. Matter of fact, they allege that. There's allegations that some of them suffered damages during some Hurricane Sandy because they were a warehouse in New Jersey. There were some that were supposed to be kept in a special area that were never supposed to be sold. There were thousands of paintings. I mean, to make that claim where there are particular ones from particular places, from particular times. I mean, are anything that could pinpoint anything? I mean, I understand when you write a complaint, you don't always have all the information in front of you, and you sometimes need discovery to do that. But is there something more than just there's a pattern of taking pictures?
Your Honor, I'll just note that this is the amended complaint. The prior complaint was dismissed as well and did have further information about that. That's not in the record here. That did actually attach videos that we believe showed Libra taking paintings. And I'll note that the Court of Appeals has made clear that where there is information, particularly in the hands of the wrongdoer and not the accuser, it would work an injustice at an early stage of a case where the pleading could be amplified through discovery to dismiss the claims. And we believe that's the case here. And I will note that even if it were not, there are claims that are not subject to the exculpation clause. There are claims for removal of the directors and officers, for equitable relief, and claims against Libra in her capacity as an officer of ALP. And those are just not subject to the exculpation clause.
Okay.
And I'll note that it's not merely the taking of artwork or funds. We also talk about the particular New York Times article where Libra gave false statements, the fact that 40 employees were terminated from ALP, not replaced, and it could no longer function, that they lost all of their customers and all of their funds.
It's interesting that you cite to the New York Times article because that doesn't suggest anything having come from Libra at all. I reread it just before argument because I was curious.
Thank you, Your Honor.
There's nothing that ties that to the defendants.
Thank you, Your Honor. It does reference Libra. However, that is not dispositive. Whether it says that she gave them the information or not, we pled that she did. and we are entitled to move forward on that claim on that basis. The article
So
stating,
conclusory allegations, you can just put anything into a pleading and we accept them as true? Is that the law in New York?
no, Your Honor, and we don't believe the allegations are conclusory.
So then answer my colleague's question. What's the false information?
The false information was that effectively ALP was producing counterfeit goods because Peter Max was no longer able to paint. And it was selling paintings of Peter Max once he was no longer able to paint. That was the false information that she provided. And the fact that it doesn't say that.
What is the basis of that allegation?
Excuse me, Your Honor?
What's the basis of that? What's the factual basis of that allegation?
You mean why did we plead that?
No, not why. What fact are you pleading that would support that conclusion? Because obviously that's a conclusion. She gave the information, doesn't say it in the article. So your conclusion is she gave it. And I'm asking you based on what facts, because you haven't pled a defamation claim.
That's
so
correct,
it's a breach of fiduciary duty claim. And so as we know, those have to be pled with specificity. And so I'm asking you, what fact are you basing that conclusion on?
Thank you, Your Honor. In paragraph 55 of the complaint, which on record page 271, we allege that Libra provided false information to the Times reporter. I know that that's your conclusion. I'm asking you, what is the basis of that conclusion? Where do you come up with the how did someone tell you it? You can't tell it from the face of the article.
Right.
So my question is, what's the factual basis for that conclusion?
Your Honor, my client verified that he had knowledge of this allegation. We did not plead where he got this information or how he got this information, but he verified that allegation. And on a pleadings motion, it's entitled to be credited.
Okay, could we are going over time in every single case, so could we hear from the other side? And Ms. Klein, you'll have a couple minutes to respond, okay?
Yes.
Thank you
Your
very
Honor.
much. Respondent? Ms. Levine, is that your name? You're on mute.
My apologies. I was.
That's okay.
That's
gonna be the famous line from this century. Hi, you're on mute.
Yes. So, Your Honors, I plan today to address three things that are arguments that appellant raised in reply, sort of for the first time. So I think it seems obvious to everyone that unless appellant can point to somewhere in the complaint where there's an allegation of bad faith or personal benefit or intentional misconduct, his entire amended complaint, Justice Bannon was correct in dismissing his entire amended complaint.
Well, let me ask you, if I may, in that regard. I understand that breach of fiduciary has to be pled with specificity, but as I said to your opponent, your colleague, that there were thousands and thousands of paintings here. And how really were they in a position to know? I understand Libra lived in California for a while, and Adam for a while was the person that was in charge for some time when Peter Max was no longer able or wanting to continue running ALP. So we put Adam in charge and he was on top of everything. How really were they able to know what Libra came in and did once she and Mr. Anderson came in, what they may have taken, what they've done? If there was some good faith in their arguments, wouldn't they perhaps need some type of discovery before they could put in their details?
Right. I don't think, Your Honor, that there's any good faith in these allegations. I think that the specific allegations that we've heard from my colleague of misappropriation of artwork, money, and cash, that's really the first time in the reply that we've really heard that argument. There's the one allegation, yes, it's there, it's in the complaint, it's at paragraph 100, which is almost the end of the complaint, Quite frankly, I think they forgot it there when they amended the complaint, and now they're pointing to it to try to save this amended complaint. What happened here is that Adam Max's, and my colleague referred to this, his original complaint, which was filed in January of 2019, was full of inflammatory allegations that Libra looted assets and artwork from ALP. Of course, what made it worse is that this was front and center in Adam Max's order to show cause, asking for a temporary receiver to Justice Bannon. He lost that, that did not work. And then he chose himself to allege his complaint. He dropped all of those allegations of looting, of misappropriation, because he knew he could never make them out. They're not true. And he I think he forgot one in there, and now he's pointing to it and saying, look, that's the bad faith. It's wholly conclusory. There's no facts. I mean, I'm not going to repeat it. I think Your Honors get it. There's absolutely no factual allegations of any misappropriation, and essentially Adam conceded it himself, that it was made out of whole cloth, by amending his complaint and taking all of that out. The original complaint had two causes of action. One was for conversion against Libra for this, misappropriation, and the other was for unjust enrichment against Libra and Michael Anderson, and he dropped all of those. This, Your Honors, it's in the supplemental record, pages 19 and 20. That's where, before Justice Bannon, we made this argument that I made just now about the fact that he amended his complaint, took out all of these allegations. And below, Adam was silent on it. He did not say, no, they're wrong. We still think that's the fact. It's just, we took it out for some other reason. He didn't address that at all, of course, conceding it. In his opening brief on appeal, he didn't say anything about that. And then all of a sudden, in a reply, he points to this. Of course, this should be rejected. Similar with his the other kind of allegation that we see in the reply brief is this idea of a personal vendetta. So that, everything that Libra and Michael Anderson have done was animated by personal vendetta. That's, again, it's one time in the complaint. What vendetta, what agenda, what conspiracy? It's not detailed. There's no factual allegations at all. Really, what this comes down to is Adam's, recurring argument that because Libra is not managing this company the way he would have done it, that necessarily she's animated by some sort of bad faith purpose and not, any business judgment or any strategic good faith purpose for the company. So that's the other point I was going to make is that he alleges, so this is in paragraph 73 of his amended complaint. That's the only place where we see in the complaint, personal vendetta. He says, he alleges that, quote, conspiring with Mary Max and Lawrence Flynn and others for their own personal vendetta and agenda, that Libra and Anderson violated their fiduciary obligations to the company and for their own personal benefit. Of course, in the same breath, he says that Libra has essentially bankrupted the company. I'm not saying I agree with that. I'm saying that's what he says. So, where's the personal benefit? There is none. He doesn't even allege one. I want to address briefly, if I still have a few minutes.
Yeah, well, you don't have a few minutes, but you have a minute to address one point.
Okay, great. So the one point I want to address in closing is the New York Times article.
Yeah.
The allegation is in one paragraph. I think it was quoted a moment ago that Libra, quote, allowed a reporter from the New York Times to have access to Peter and provided the Times and its reporter with false information. Essentially, I'm not going to read it all, but essentially, information that ALP sold counterfeited art. Of course, as Your Honors have pointed, the New York Times article doesn't back that up. But even before we get there, there are no factual allegations at all to back up this claim. What information? How was it provided? Of course, there's, as Your Honors know, there's a number of lawsuits that have been filed against Park West, against others. To the extent the New York Times have read allegations in those complaints, that doesn't make out a breach of fiduciary claim. To the extent that Adam alleges that Libra, quote, even if she could have given the New York Times access to Peter Max, again, that doesn't tell us anything. How's that a breach of fiduciary duty? What kind of access? What did she do? Even if it were true, they're not sufficient. And there is one additional line from the reply that I want to address, where Adam writes in his reply, this is at page 17 and 18, respondents, that's us, do not deny that Libra's correspondence with the New York Times was followed by a published article dated May 28th, 2019. First, there's no allegation in the complaint about correspondence between Libra and the New York Times, so this comes out of left field. I don't know what he's talking about, so I can't respond to it. And the fact that Libra doesn't deny anything, of course, this is an appeal. It's a motion to dismiss. She wouldn't file an if she had the power to deny, she would deny the whole thing. But of course, she can't do that here. So that's just an irrelevant argument. And finally, to the extent that that's the heart of the allegation that Libra spoke to the New York Times, that doesn't make out any misrepresentation or breach of fiduciary duty. And unless your honors have questions, I'll end it there.
Okay, thank you very much. Ms. Klein, you have 2 minutes to respond.
Thank you, Your Honor. I'll note that my colleague spent most of the time talking about bad faith, New York Times article, but she did not address the allegations that bad faith is shown by the fact that under respondents' leadership, ALP lost every single customer, can no longer function, fired 40 individuals and did not replace them so that ALP can no longer function, and effectively destroy the business. She also claimed that the entire complaint, appellant's entire complaint, fails for failure to allege bad faith. I believe she was referring there, Your Honors, to the exculpation clause, but the exculpation clause does not bar the claims that do not seek damages, and it does not bar the claims that do not that pursue claims against Libra in her capacity as an officer, not director. With respect to the misappropriation allegations, my colleague stated that there was only one paragraph in the complaint. That's false. If you look at paragraph 73, it also detailed that she had engaged in a pattern ongoing of misappropriation from the corporation. Appellant did not amend his complaint in an effort to concede that never happened. He retained new counsel, had a new complaint that he felt was stronger, and put that in. There was never a concession that Libra did not misappropriate from ALP. That did not happen. And with respect to my colleague's claim that there was no allegation in the complaint that there was correspondence between Libra and the New York Times, that too is false. As I mentioned earlier, Your Honors, we alleged that Libra directly provided information, false information, to the New York Times. Unless the court has any further questions, that is all I have.
Okay, well, thank you both very much for the arguments this afternoon, and have a good evening.
Thank you, Your Honor.
Thank you. And I believe the last case for argument is New York Studios versus Steiner Studios. So the appellant, you may begin. Mr. Mandel, is that you?
Yes, thank you, Your Honor.
Okay, go right ahead.
May it please the court, my name is Evan Mandel and I represent plaintiff appellant New York Studios in this matter. New York Studios contributed capital worth over $10 million to Eponymous, and as a result is entitled to at least 8 figures of distributions under the waterfall and the operating agreement.
And where did you plead anything about that in the motion court?
Sure. I think there are 5 key facts that were pled, and I can walk through each one. On page 74 of the record, we plead that the operating agreement provides a waterfall for the first tier, of which is the payment of what the operating agreement calls return.
Okay, but that doesn't address the fact that you're now claiming that they undervalued your client's investment. Where in the motion court did you claim that they undervalued your investment?
I think that would be at pages 67 and 95 of the record. where we say that New York Studios contributed over $6 million. We believe it's over $10 million, but it was over $6 million in various agreements and rights. And then on page 92 of the record, we say that they have essentially gerrymandered or engineered everything to make it so that they receive all the profits, even though that's not what's called for in the operating agreement.
So none of those actually state that you claim that they undervalued your contribution, right?
I think pages 292, 293, and 293 are where we make those allegations, and I think we're entitled to every inference on that. I'd also point to the operating agreement itself. The operating agreement itself spells out what contribution we made, that we were required to make the contribution, that they were required to value the contribution, and the complaint makes clear that they did not value the contribution as they were required to.
Now, these are all contributions your client made more than 20 years ago, right?
Most of them were made over 20 years ago. And if
right,
you're
so why hasn't the statute of limitations long since run on any claims related to the valuation of those contributions?
Sure, that issue was litigated before Justice Ramos in the 2012
so why are you asking us to address it again?
Sure. Well, Justice Ramos decided for us on that issue. He decided that the accounting claim was valid going back to 2006, and the first distribution was not paid out until 2008.
And we reversed that.
Not on the timeliness issue.
No, on the pleading issue, and then you didn't do anything with it.
Well, what we did was under CPLR 205, we filed a new action, and we get the benefit of the earlier date because the new action was filed within 6 months of the old action. Justice Ramos is clearly held, and the other side actually collaterally stopped on this issue, that we get the benefit of 2006 beginning our claim on the accounting. And the first distribution was not paid out till 2008. There's no question that the entirety of our claim regarding the distributions is timely under Justice Ramos's decision. And I guess I should add, they didn't appeal Justice Ramos's decision on that issue. That issue has been fully litigated by the courts. And I want to, from a big picture perspective, I want to emphasize that the arguments that the defendants are making are really not arguments on the merits. At this point, with respect to the two wrongs that are at issue here, the usurpation and the failure to pay distributions, there's really nothing in their papers that says that those aren't valid claims. They make a whole series of procedural arguments, really a litany of procedural arguments. But I think these courts, as Justice Gesmer said earlier today, have a strong preference for deciding things on the merits. I think this should be decided on the merits. But if the court was going to decide it on the basis of procedure, I think we would still have far better the far better side of this argument. They themselves misrepresented orders of Justice Ramos and this court to Justice Cohen. And on the basis of those misrepresentations, they obtained this decision on collateral estoppel. They are not even defending that collateral estoppel position at this point. They claimed that this court and Justice Ramos decided that our fiduciary duty claims were barred by Section 5.8 of the agreement. In fact, Justice Ramos concluded that our fiduciary duty claims survive Section 5.8 of this agreement, and this court agreed. Justice Ramos did conclude that our breach of contract claims were barred by Section 5.8, but
there was a phone ringing before. Why didn't you pursue the breach of fiduciary duty claims if Justice Ramos left them in the case?
The other side appealed them to this court. This court ruled there are three claims at issue here. The constructive trust claim was not at issue in the 2012 case.
Right.
That's
Okay.
a new claim right now. But the usurpation claim,
Right.
This court decided we had failed to state a claim. And with respect to the accounting claim, this court found the only basis for dismissal.
That you had made a demand.
Correct. So we made the demand, and then as contemplated by CPLR 205, we filed a new action.
But one of the things Judge Cohen asked during the argument in Supreme Court was, how come you can't, since you're a member of eponymous, even if you're a minority member, why can't you get an awful lot of these documents that you're wanting, the accounting, the books and records? Why can't you see those, notwithstanding even the existence of this lawsuit, and then would be able to make a lawsuit based, or perhaps bring a lawsuit based on problems that you find once you look at those documents? Those aren't really discovery documents. You're entitled to those documents, even if there were no lawsuit. No?
Your Honor is exactly correct. We are entitled to those documents, but the defendants have breached their obligation to provide them to us. We have received documents from 2008 to 2015, but we have not received documents since 2016 for the most part, and we have demanded those documents, and they have not been provided to us. But the accounting
counsel, this is Judge Scarpullo. Did you plead a claim under the BCL for their failure to? Did you?
No, we pled an accounting claim.
So why not plead the claim that you clearly are entitled to plead?
Yeah, I mean, respectfully, I think we're entitled to plead both. I agree there is also a BCL claim there, but just the existence of a BCL claim does not mean that we don't have a common law right to an accounting claim. I think we have a right to both, and we're entitled to pursue both. I'm sure if we had pursued both, they would argue to one should be dismissed as duplicative of the other. But the accounting claim, of course, doesn't just seek the documents. It also seeks, under the Court of Appeals decision in the Roslyn School District case, it seeks that the monies that were misappropriated be returned to us with respect to the distribution. So the accounting claim seeks far more than just the records.
Okay. Are there any other questions right now, or should we?
I just want to ask one more question.
Sure.
You're saying that Judge Ramos didn't opine on the applicability of the exculpatory language in the agreement?
No, that's not what I'm saying at all, Your Honor. I'm saying he opined with respect to each and every claim, and he came out differently with respect to different claims. With respect to breach of contract claims, the Steiners won, and he said Section 5.8 gets you out of any breach of contract claims. With respect to breach of fiduciary duty claims, he said Section 5.8 absolutely does not get you out of that claim. And that's why the usurpation claim and the accounting claim that we're pursuing now, both of those Justice Ramos found survived Section 5.8. I would also may I briefly address the usurpation claim?
You have 30 seconds, and then we'll let you speak more later, but go ahead.
Okay, with respect to, I just want to cite 4 quick facts that support our usurpation claim that are in the record. The first is that there was a competition to obtain these development rights, that you needed these development rights. They were exclusive development rights, and we won that competition. That's on pages 290.
Counsel, when was the first time you raised this claim?
The usurpation below? We absolutely, yes, we raised this claim below. In fact, we raised it at the earlier in the earlier case. I will absolutely concede that we could have raised this claim more clearly than we did. I don't think the issue is that we didn't plead the claim. I think the issue is that we tried to plead a whole lot of claims, and when you look at all of those claims, they were broad and scattershot and difficult to understand how any one of them was pled. But what we've done on this appeal is we've narrowed it so that we're just seeking 3 claims that arise out of 2 wrongs: the failure to pay distributions and the usurpation of the exclusive right to expand within the Brooklyn Navy Yard. And just to be clear, to answer your question, Justice Singh, we pled these 4 facts, the first of which I already mentioned is on 290 of the record, that we had the exclusive right, that Eponymous, had the exclusive right to expand a studio business in the Navy Yard. 2, that New York Studios contributed this right to Eponymous. That's on pages 297 and 95. 3, that the defendants used Eponymous's development rights to compete against Eponymous. That the Steiners used Eponymous's development rights to compete against Eponymous. That's a 292 paragraph 14. And 4th, that the defendants expanded the number of studios but kept the profits for themselves. And that's at page 22 of the record, paragraph 15. And I'll just note that the first expansion occurred in 2012. So this usurpation expansion issue is far more recent than are the other issues, but none of them are time barred under Justice Ramos's decision. Thank you, Your Honors.
Thank you. You'll have a couple of minutes for responsive. Ms. Guazzo?
Yes, good afternoon, Your Honors. This is Delia Guazzo representing the defendants, respondents in this case. I have a few points that I wanted to make, but before I get to those, I want to address two of the questions that Your Honors had raised with my adversary. The question of the failure to pay distributions arises out of a claim that the capital contributions out of New York Studios claim that its capital contributions were never appropriately valued. That goes back to capital contributions that were made only in 1999 at the establishment of the joint venture and the operating agreement. That specific claim was made before Justice Ramos and was dismissed on statute of limitations grounds. So the idea that they can now come back and seek to revisit it under the guise of distributions that are owed later is nonsense. It just doesn't fly. It was the 9th cause of action for specific performance in the amended complaint in the first action, and it was dismissed on statute of limitations grounds, and that can be found in the record on, I believe it's record page 107, 106 and 107. So that disposes of any claim with regard to lack of distribution of assets. Also, there was a specific misrepresentation with regard to what Justice Ramos did with regard to the exculpatory clause. Justice Ramos found that the exculpatory clause provided a complete defense and indemnification with to the managers for their personal liability for their conduct as managers. That
So,
applied.
counsel, this is Judge Scarpullo. So, in fact, it wouldn't cure that to just name the Steiners individually, correct? Because
that's correct.
Justice Ramos found that that exculpation clause completely exculpated them in their capacity as managers, right?
Correct.
So the plaintiff says, well, let me plead, I forgot to plead them directly as managers. Let me plead them as managers, but that claim has already been dismissed and there was no appeal from that, correct?
It's worse.
That's what I'm thinking. That's what I thought Ramos said.
That's absolutely correct. And not only was it not appealed, a notice of appeal was originally filed by New York Studios, and they withdrew it with prejudice. So this wasn't just a matter that they didn't bother to pursue it. They made a strategic decision not to pursue it. In addition, the representation that Justice Ramos distinguished between breach of contract claims and breach of fiduciary claims is absolutely incorrect, because the 6th cause of action, which was a breach of fiduciary claim in the first action, and the 11th cause of action, which was a breach of fiduciary claim in the first action, were both dismissed on the basis of the exculpation of liability. And that can be found in the record at pages 107 and 108. So those are the two critical things that I wanted to address right up front before getting to my critical points. The Justice Cohen dismissed the complaint and denied the appellant's motion to file an amended complaint. Our position is that the decision of the court below should be affirmed in all respects. And there are really only two critical issues: whether or not the complaint was properly dismissed and whether or not the motion to amend the complaint was properly denied. With regard to the dismissal of the complaint, all of the causes of action in the original complaint for usurpation, for an accounting, and for a constructive trust require a fiduciary. The plaintiff did not name or sue a fiduciary in the original complaint.
So, counsel, let me interrupt you. So that is why I was asking about the exculpation clause. And so your argument is that you can't, the plaintiff asked to have the Steiners sued individually, but Ramos already ruled on that.
Well, it's more than that. There is no, you can't have a claim for breach of fiduciary duty or usurpation of assets or for an accounting or for a constructive trust other than against a fiduciary. In the original complaint, New York Studios made the strategic decision not to sue the individual Steiners in their managerial capacity. They tried to bring them in as individuals under an alter ego claim or a dominion and control claim, but they specifically pleaded that the Steiners are not parties to this action in their managerial capacity. So they were not sued as fiduciaries, and they made a claim against the other member as a fiduciary, but Judge Cohen properly found that a member has no fiduciary liability, and New York Studios has conceded that in this appeal. So with respect to the original complaint, there were no fiduciaries, therefore the action was properly dismissed. Judge Cohen also found that even if he went past that determination, the substantive claims in the complaint were not sufficiently specific. He compared those claims to the ones that this court had dismissed in the first action, and they were not different in any material respect. But I think that those two claims in and of themselves dispose of the complaint without any issue, and I don't think that that New York Studios seriously claims that was incorrect. So the next question is whether or not the proposed amended complaint or the application to file an amended complaint was properly denied. And the answer to that also is yes. The proposed amended complaint did not cure the lack of specificity that this court had already found when it rejected the complaint in the first action. The amended complaint in the second action, in Judge Cohen's action, and the original complaint did not change the allegations regarding usurpation of assets in any way. So if you look, they are addressed in record that the comparison of what was in the claim that this court found wanting and the pleadings in this second action can be found in records page 10 to 19, and that lack of specificity remained, and Judge Cohen relied on that in denying leave to amend the complaint. And we have to put this in context. This is now a series of claims that were originally made in 2012, where I'm talking about 10 years ago. We've gone through a first complaint, a complaint in the first action, an amended complaint in the first action, a complaint that was seeking to address what this court found in dismissing. So there was a complaint in the second action, and then a proposed amended complaint in the second action. And none of those pleadings was sufficiently specific to withstand what Justice Scarpula addressed in the prior argument as to the level of specificity that is required.
I have to add one last comment. I mean, the reason from where I sit and read this case, the record here, this operating agreement is pretty tight. It's pretty tight. I mean, you know how it goes. That's what it is. I mean, you know, when I read it, I was like, wow. I mean, it's a pretty comprehensive and pretty tight operating agreement.
I would agree, Your Honor. I would agree. I think that there's no basis for doing anything other than affirming the decision of the court below, both with regard to dismissal of the complaint and denial of the motion to amend.
Does anyone have any further questions for Ms. Guazzo? Okay.
Then I'll rest on my brief. Thank you, Your Honors.
Thank you, Ms. Guazzo. Mr. Mandel, let me ask you something. Could you address Ms. Guazzo's point about, which seems to be one of the main bases that Judge Cohen dismissed the case, because he said there was no fiduciary here. The member, the non-managing member, which is Steiner Digital Studios, can't be sued for breach of fiduciary duty, and that the court has already found that the individuals could not be held responsible under a breach of fiduciary cause of action because of Section 5.8 of the operating agreement, which, I mean, maybe you were under pressure to sign it than your clients. You may not very well have been the attorney 23 years ago, whatever, but that's what is in the operating agreement. So how do we get past those things to get any kind of claims here?
I totally understand. And there's a misunderstanding here. It's because some of the information that was just provided to you was absolutely false. And I'm going to read to you Justice Ramos's decision. The first claim in the Justice.
Tell me what page?
110. 110.
Thank you.
The first claim in the Justice Ramos case was the usurpation claim. The 12th claim was the accounting claim. This is page 110, first full paragraph. Quote, The first cause of action for breach of the operating agreement and the 12th cause of action for an accounting survive the motion to dismiss, but are limited to conduct that occurred within the 6 years of the limitations period. It is absolutely false that Justice Ramos dismissed these 2 breach of fiduciary duty claims. He absolutely found that these 2 breach of fiduciary duty claims could be sustained. Those are the same 2 breach of fiduciary duty claims that we are pursuing right now. And that's why we're pursuing them, because these are the ones he specifically found we could pursue. Now, she said something else.
Against whom? The individual Steiners as managers?
Yes, the Steiners and SDS. They were pled then against the Steiners and SDS, and we're pursuing them now again against the Steiners and SDS. Now, she said 2 other things that were also false. She said the 11th cause of action was dismissed under section 5.8. That is false. Page 108 of the record. It was dismissed because it was duplicative of another claim. It was not dismissed under 5.8. The third thing she said,
Counsel, wasn't that other claim dismissed because of the exculpation clause?
That is correct. But
so I mean, isn't it just an easier way to say same defense applies to just say it's duplicative?
But here's the thing. Justice Ramos did not say at any point that any of the breach of fiduciary duty claims were being dismissed on the basis of 5.8. He cited other reasons for dismissing them, but he did not cite 5.8. So with respect to the 11th claim, he said it was duplicative. Again, that's record 108. With respect to the 6th claim, which was styled as a fiduciary duty claim, he said this is a breach of contract claim. This is page 107 of the record, and he said I'm dismissing it as a breach of contract claim. He did not at any point there's not a single word of his reasoning which says that a breach of fiduciary duty claim can be dismissed on the basis of 5.8. And to the contrary, he specifically found that the 2 key breach of fiduciary duty claims that we're pursuing now sustain 5.8. And that's what I read to you at 110 of the record. I will also say that the idea that 5.8 could abrogate all fiduciary duties, that is not the law in the state of New York. I mean, I think they're collaterally stopped on this issue because they lost before Justice Ramos, and that's the end of that. But if you were to get to that issue on the merits, does 5.8 bar a breach of fiduciary duty claims? That is absolutely not the law in the state of New York. An exculpatory clause cannot, as a matter of law, abrogate claims arising out of self-dealing or misappropriation. And that's precisely what we're talking about here. And they don't even argue to the contrary in their briefs. In their briefs on appeal, they did not even attempt to defend section 5.8. They made a whole host of other arguments, but they were not arguing that 5.8 got them out of the fiduciary duty claims because Judge Ramos found to the contrary, and their suggestions to Justice Cohen below were an absolute misrepresentation of what Justice Ramos found.
Okay, Mr. Mandel, Ms. Guazzo, thank you very much for the arguments. We'll certainly take a look at the points that you raised. So thank you. Oral arguments for today are now concluded, and the court is adjourned. Thank you, and I hope everyone has a good evening.
Thank you very much.
Thank you, Your Honors.